Morning, George. Good. All right, if I call your name, please come forward. Let's see, William Bonilla. Good morning, you're William Bonilla. And so, Mr. Bonilla, this is your initial appearance. You have two cases. You're on probation, and there's been a motion to revoke your probation filed in cause number 25 DCCR 0174. And you have a new indictment in cause number 25 DCCR 0719, charging you with evading arrest or detention with the use of a vehicle from May 10th of 2025. And since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
No.
Okay. Trying to see who set a bond and, oh, here it is. Give me just a second to look at something. And do you have the scram device?
Yes, ma'am.
All right, so your probation that you're on was a reduction to a misdemeanor, and so that's why I said, okay. All right, so what I'm going to do, Mr. Bonilla, is reset your case for about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before that next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire a lawyer before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk right here, she will give you that reset notice. What's wrong with your, Kelly, you're off. Huh? You can't, don't turn them with your hands. We've got to do it on the computer. It just makes it, they just go right back to where they were if you turn them, unless you turn the whole thing, but if you turn the camera, they're electronic. Yeah, and I don't know why it keeps getting, huh? And you know how, once it does come up, you know how to do the little program that changes where it's directed.
I don't know how it went off. I don't even know how to do that. You know what I'm saying?
Can you exit and then go back in maybe?
Yes, ma'am.
I hate it when it's me.
There's no way for us to test this stuff when I'm hooking it all up, you know what I mean?
Yeah, no, it's fine.
I apologize.
You're good. Christopher Davis. Good morning, sir. You're Christopher Davis. Mr. Davis, did you get someone hired?
Kyle right there, so I got a meeting with him at 1 o'clock today.
Okay. Why are you just now meeting with them today?
I've got to try to call a couple more lawyers just to kind of see what I can get, you know, the kind of price that I can get. I was going to hire right. I just got a little job, about 3 week job that I feel like this job I can hire an attorney. So.
Okay. All right. So you've come several times. This is going to be your last reset. You need to try to get someone hired before the next court date. If you can't, you need to talk to at least 3. You need to bring me that information. Also, I want to see pay stubs when you come back as well.
Yes, ma'am.
All right. Step in front of the clerk.
Thank you.
Do I need to move that?
It's probably fine for right now. It'll get the defendant, I think. Dylan Wilkinson. Good morning. Are you Dylan Wilkinson?
Yes, ma'am.
Let's see. Mr. Wilkinson, this is your initial appearance in cause number 25 DCCR 0260. You're charged with deadly conduct, discharging a firearm from September 13th of 2024. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, not just yet. No, I was gonna ask if I could have a little bit more time in order to come up with more funds to hire an attorney.
So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice.
Cordell, Beard,
Brianna Kleinan. Brianna Kleinan. That's not one of the ones.
No response, Your Honor.
Her bond will be forfeited for non-appearance and reset at $100,000. Okay. Mark Garcia. If you'll call the name Mark Garcia. And he called.
Mark Garcia.
Let's see.
No response, Your Honor.
All right, he did call and say he was going to be late. I will issue a bond forfeiture for non-appearance and reset his bond at $100,000. If he shows up, just let me know and I'll recall that. Drayden Rose. Good morning. Are you Drayden Rose? And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the 3rd-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm in court.
How old are you?
18.
Are you still in school?
I got my GED.
You got your GED?
Yes, ma'am.
So are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of me raising your bond and you would have to go back to jail for not following that court order. Do you understand all that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Lance Charbino. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey is. Cody
Uh-huh.
Crenshaw. He asked for 4,000 down.
Okay,
And as soon as I get that, which should be about 3 weeks from now.
okay.
And then I'll be able to get him hired for.
All right. You've been here a few times, so I'm going to reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not going to work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right. Step in front of the clerk. She'll give you a reset notice. Presley Viltz. Good morning, you're Presley Viltz. Did you get someone hired, Mr. Viltz? No. Who'd you talk to? Okay, did you write down the names? Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talk to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them.
Yes, ma'am.
So what part of bring me back the names of who you've talked to did you not understand?
I understood. Okay.
You just forgot. Okay, so you're in felony court. You don't just forget, because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them. Did you talk to 3?
I really talked to
You really talked to, so when you first answered, you said you talked to 2. So be careful what you're saying. All right. And you're probably nervous right now, and I get that, but be careful what you're saying, because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute, because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge. Let me know about where you're working, bring a pay stub when you come back. The more information you bring me, the better things are going to go. Does that make sense? All right, 2 weeks, step in front of the clerk. Caitlin Talmore. Good morning, you're Caitlin Talmore. And Ms. Talmore, this is your initial appearance in cause number 25 DCCR 0595. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk. She'll give you a reset notice.
Fine.
Janisha Leonard. Good morning, you're Janisha Leonard. See, and Ms. Leonard, you have two motions to revoke your probation, and then you have a new case in cause number 25 DCCR 0297. And I set bonds, and you've made bonds on all of those. And have you had an opportunity to hire a lawyer? Okay, so you need to get someone hired. The fact that I set those bonds at what I did, even when the state asked me not to, you've got some serious stuff going on. You need to try to get someone hired if you can before that next court date. So I'm going to reset your case for 30 days. You need to try to get someone hired. If you do, bring the reset notice to them. They'll tell you what to do. Go ahead. Well, you need to try to get a job first. And you need to apply to at least 5 jobs a week, and you need to bring me proof of that. Okay, if you do get a job, bring me some proof that you have a job. In the meantime, I'll also want you talking to lawyers. Bring me back the names of the lawyers you've talked to, at least 3, so I know you're trying. Bring me the information about that you're trying to get a job, and then we'll discuss all of your options. Okay, if you don't do that, then your bonds will be raised, especially on those motion to revoke probations. You'll be right back in jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. How'd you make all those bonds?
My family came together.
Okay, well, you might need to get with them on this too.
Yes, ma'am.
Okay. I said a bunch of bonds on motion to revokes today. I look back and I think, what was I thinking? Anthony Salvato, this is another one. Because I don't usually do all of this. All right, you're Anthony Salvato. Mr. Salvato, you're here on a motion to revoke your probation, and I set a bond in your case. Let's see, I feel like we had received some letters. You were participating in the veterans
Yes.
and all of that.
Yes, ma'am.
You're still doing all of that?
Yes, ma'am.
Good morning. What is your name for the record? Okay, and who are you with, Ms. Branch? Okay, thanks. Sorry. And so has he been following through and everything with regard to probation? Okay. Have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right. Are you working?
No, ma'am. I've been trying to do the program that we have. I have had a couple of interviews, which I have not been successful because of my record, my health diagnosis. It's been very difficult. I have attended some veteran work job fairs, and that was unsuccessful as well.
Okay.
So, but I have been traced, and I am seeing a employment counselor once a week.
Okay. What I'm going to do this morning, Mr. Salvato, and I'm looking back, I have some documentation from the Veterans Association and things like that with regard to when I set your bond. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. All right, step in front of the clerk. She'll give you that paperwork. Thanks, Ms. Branch. Sorry, I didn't recognize you. I didn't know who. I don't know if I've seen her in here. Daryl Spencer. Good morning, you're Daryl Spencer. Mr. Spencer, did you get someone hired? Did you already hire him?
I was gonna pay him today.
You're, okay,
Yes, ma'am. I have money on me right now.
okay. Did you talk to him about where you were gonna meet, or?
I told him about on my case and stuff like that. He told me to make a payment plan with me because I talked to Marsha Bowman and she told me she couldn't.
Okay, so you have the money to hire him?
Yes, ma'am.
All right, I'm gonna reset your case 2 weeks.
Yes, ma'am.
You need to get him hired before that next court date.
Yes, ma'am.
Right. Step in front of the clerk, she'll give you a reset notice.
Yes, ma'am.
I do too. I do too. I can't remember for sure, but I think so.
Go down, just go down there when you're finished here. Hold on just a second.
No, from before. I can't remember.
Sign right there.
Let me check your share.
I know, she'll remember. I'll ask you later.
Thank you. Yes.
Yeah. I appreciate today that solid.
Better choices.
Better choices. I wish I had said something now. He knew. He knows he went viral too. Poor thing. He might be. Somebody. I know, right? Kyle was in here. I know, I was gonna try to get him first because he was being on time and patient.
Judge, if you want to find Gertz, he's not gonna be here.
He's-
He's in trial,
Oh, yeah.
and I have his, announcements, if you want.
All right, on, let's see, Ms. Malfino's case on Dustin Knight, that's a pretrial. Mr. Gertz is not here, but his announcements.
Just read that one.
I have filed and agreed.
That's
Oh,
on the
that's
other
in the
one.
other one.
That's the one I got.
Okay,
I believe she is ready, Your Honor.
okay. And they were talking about a possible resolution last week, but they didn't do that. So if you'll get with them, her. All right, then I'm gonna number, is Dustin Knight here? Did you tell
I
him
don't
not to
think
be here?
they didn't.
Okay.
They're not gonna.
And then on Jesse Salinas,
We spoke, last week, Judge. Me and Mr. Gertz.
uh-huh,
We're close, the agreement, if the court will allow us one recess, we'll be ready at that time.
okay,
I've got all my witnesses, claiming witnesses in Florida, I've got witnesses out of state.
okay.
But I've talked to him about it and he's all right.
I mean, they'll still be out of state next time, right?
I'm gonna say,
Okay.
but we didn't, I don't.
I mean, I didn't mean to be smarty about that. I'm just
No,
saying.
no, I understand, but that's, we were in agreement on that. I don't believe he was ready as well.
I gave you a trial. For the 8th.
But a quick recess.
Okay. You did, Kelly.
Yeah, we're doing the bond ones today since we're off next month.
Oh, this is for trial in
2 weeks.
2 weeks.
2 weeks. I meant to call you, but your email.
Okay, I'm going to grant the motion for continuance this time in Mr. Salinas' case, but there will not be another.
Yes,
Thank you. And if you'll just relay that to Mr. Gertz
I
as
will.
well.
Yes, ma'am.
Yeah, good.
Judge, can we call Mr. Mitchell's case on Van Wright?
Morning, Your Honor.
He's,
Good morning.
Mr. Venner? Judge, this was one,
John Van Wright. Good morning, sir. You're John Van Wright. And this is 24 DCCR 2485. And then there's the motion to revoke probation in 15 23582.
Judge, I know Mr. Mitchell was trying to get with Mr. Smith. He didn't realize he was out last week. He was having trouble watching the video they need to watch. I know enough about this case to know they need to watch that video.
Okay,
So I'm asking for a reset so they can do that.
okay. I will do just a normal reset. Obviously, if there's any issues, if you can get with Mr. Nichols or Ms. Malfino, I'm sure either of them will help you work that issue
Absolutely.
out, and we'll get an
I think it just
announcement.
wouldn't play for him, so he was going to come to our office and do it. And
Okay,
if he needs me to do it for him, I'll gladly do it.
okay,
So I'm setting trial this morning in the 128th with Mr. Gertz. We're both under trial protection.
okay.
As soon as that ends, I'll give Mr. Nichols a call.
Perfect. And Mr. Smith might be back by then as well. And so, but if not, just get with Mr. Nichols or Ms. Malfino. They'll help you out. Okay.
Thank you, Your Honor. I appreciate it.
Stay in touch with Mr. Mitchell. He'll let you know when you need to be back.
Thank you.
Thank you. Mr. Walker, are you ready on Adrian Housley sentencing?
Yes, ma'am.
Good morning.
Good morning, how are you?
Good. How about you?
Doing good. What we're talking about, I have an intention to try and read her. That's all in this announcement document.
Oh, for next, yeah, in 2 weeks, for sure.
Hey Bruce, on yours, we're starting off on yours with Damien of, where's Mr. What's our plan here?
I need to get, we haven't had anything on the box.
Sir?
We haven't heard anything about the new good documents. The new good documents.
I don't know what you're talking about.
Jack, Judge, back on 30th, Mr. Eckhart. It was a 30th. There was an order signed by you that Do Good Credit Union would provide some documents for you to inspect in camera. I've got the email that shows that it was sent to their attorney. And I do not have a response. It wasn't going to come back to us. It was supposed to be sent to you to do an in-camera inspection. I don't know if the court ever received anything from them or not.
I don't remember seeing it.
It's been a while. Yeah, that is. But there was a long list of things.
Well, things have changed over the office.
That's true.
Everything has been rerouted and, but it's 1,500 days. It's the longest court, it's the oldest case on the docket.
Yes, sir.
I mean, that's 5 years. That's just, people don't stand for that. That's just too long to be languishing.
Yes, sir.
And it really, I mean, searching for records after 5 years, I mean, that's another thing. I don't know why that took so long to get around to doing. Do we have anything coming in on this? On the law?
Everything that I have. I put in the-
This was.
Let's just, it was like a boulder in your shoe. It's just, you can't ignore this. That's a problem. Let's look for it and find out where it is, what was done last, and if the attorney has sent us anything, but I don't have it. No. There was a motion. I expect a motion and the order to be followed, and there's the order, and I didn't get any input. Now, if things haven't been done, what's the date on that order?
30th.
June 30th.
Yes, sir.
This is 6 weeks. It's time. Set a show cause. I want a hearing later this week, show cause of why that had not been produced, if it hadn't been. And everybody will know, so y'all can be here. And then I want the recipient of that to be here with his attorney, so we can explain what the problem is or when we're going to get something. Wednesday. I'm going to reset it for Wednesday. Yes. What?
I was gonna stay here I'm living in Longview now. I'm gonna probably have to stay here.
You want me to help you with the rent or what?
No. Well,
Clean up? Vacuum?
I just wanted
What?
to know. I'm staying at one of the hotels. I just need to let them know.
Okay.
Okay.
All right. Thanks for including me on that one. I found it.
I would,
Now I got work. I was supposed to do some house cleaning or something. But
Judge.
are you close being washed record?
Yes.
Don't worry about it. Okay, I'll see you Wednesday.
I was going to ask you about if you ever heard of that letter from General Hood to General Longstreet in 1878, the one that explained what happened in Battle of Gettysburg.
Well, you know, I was there when he wrote that letter. Yeah, well, you know, I'm a historian. I love history. So,
But if I get a copy of the letter, yeah,
Thank you.
I'll get his one.
okay, that's, I like that. Yes, 9 o'clock Wednesday.
Yes.
7. Sonia Rose, please. Sonia Rose. Yes, one, what's this?
Oh, exactly this.
This is a companion case to that one?
Yes, sir.
Well, okay, what are we doing here? Is it the same problem?
No.
Yeah, I must be.
I'm sorry, you got to speak up.
We'll give the state some information.
Okay, but once again, look, it's 1,500 days, Ron. I mean, this stuff's ancient.
Yes, Your Honor, once we
I don't like
do
this.
this, I'll find hers will go away. Yeah.
That goes along there, yeah. That's another one. Well, we've got another hearing on Wednesday if you want to be here, but if not, we'll reset it. Okay, thank you, sir. Jeremy Robertson. Thanks.
Who's president, Judge?
Thanks. What are we doing?
Please.
Okay.
Well, tell me when you're ready so we can get it up.
Judge.
Yeah, well, thanks. Yeah, that's great. It's awfully nice of them.
Yeah.
Ronald Tyler, who's next? 21-3243, Ronald Tyler. 3 cases, Ronald Tyler. Ronald Tyler. Is Mr. Ronald Tyler? Is your no answer? I hear nothing.
Mr. Gertz is picking the jury in Orange County this morning.
Huh?
Mr. Gertz is picking the jury in Orange County
Yeah,
this morning.
he's not, he needs to be here too. Are you going to be here for him?
I'm just making,
It's wrong. It's 1,400 days. He needs to be here to make some kind of announcement, so we know what we're going to do. It's 1,500 days.
I understand, Judge, but we filed a motion to continue and all of this.
It's denied.
It's
All right, how's
picking
that?
the jury in Orange County.
Okay, but the motion is denied. We're just going to keep it. Y'all ready?
Yes, sir.
All right, it's going to be first from here on. It's 1,400 days. It'll be first on every child docket. Okay, thank you. Let him know. Brendan Hardy, 1,400 days on indecency with a child and aggravated sexual assault. That's way too long. Brendan Hardy, that's set first on every child docket. Brendan Hardy, and that's the same one. That's the same kind of case, and that's 2 on each docket. Where's Brendan Hardy? Is Brendan Hardy? You know, there is no answer in the courtroom. I asked the bailiff to call into the hall for Brendan Hardy, please. Do you have a hand raised, ma'am? Are you Brendan? No, I don't know if Brendan's a male or a female. No response to that name being called in the hall. No response to that name being called in the courtroom. Defendant's bonds are all revoked. Warrants are issued for his arrest. No bonds. These are trial docket day. This is a trial docket day. No bond is ordered. Armando Alvera.
Yes, sir.
Mr. Kelly.
It's present.
Mhm. And everybody ready? 1,200 days?
We're ready,
Let's try a case.
Yes, sir. We're ready.
Anticipate entering a plea this afternoon
To the jury.
going to very professional.
And
Still got to put on the case, though.
yeah,
So.
So
All right, Alicia Jones, Justin Galmo.
First offender.
Yeah, what, yes,
Judge, on this one, we would ask for a special setting. I have two witnesses that live out of state. They're both in the military. There's a procedure for that.
well, y'all decide, y'all decide, and then I'll do it, but I can't figure it out. Y'all got to, right?
Just need to make sure that the next setting is a special setting.
Okay, yeah, let me know though. I'm not gonna invent it. Y'all gotta tell me, so I know what it is y'all are gonna agree to, right? When would you let me know?
Judge, as long as I have a setting at least 8 weeks away, I can work with that.
Anytime after 8 weeks?
I think anytime after 8 weeks should be sufficient. If it's not, I file a motion for continuance. Needed time
I
to.
have to look at my file. I'm ready to. That means.
Y'all get her, her and stay. Sarah, y'all work with Lacey on it, okay? Thanks.
Judge Worthing's office did say that they were happy to take some special settings over there. And so we have that potential as well. So
Thank you.
they said they would get a jury for us and. But I worked for once.
Okay, Anthony Owens.
Yes, sure.
Debbie Wolf. Anthony Owens, Anthony Owens. Is there any answer? No answer on Anthony Owens? I asked the bailiff to call into the hall for Anthony Owens, 24 CR 369. Thank you. So here's this. All right. Okay. Ready? 544 days. Y'all ready for trial?
Judge, if I could have about 5 minutes, I was not able to get in touch with Mr. Owens over the weekend, but I'll report quickly.
Sean, okay, let me know, please, as soon as possible. Sean Collins.
He's present, Chair.
And we're ready. Aretha Jackson.
Exactly. Yes.
Aretha Jackson.
Yes, sure. Over the first one. We should. We'll grab Cecil. Make it take off.
Y'all ready for trial?
Judge, if I just have just
500 days.
Talk, this was one of Mr. Eckert's cases. And I have.
Y'all hadn't talked to anybody since he's left?
Mr. Laird. Somebody case.
Let me know, please.
Yes, sir.
As soon as possible. Trent Mixon. Trent Mixon, Dustin Galmore.
There's a plea, if you'll give us a few.
Mariah Howard, please, John.
Your Honor, Ms. Howard, we were informed last week she's currently in jail in Galveston, and I just confirmed with the jail screen in Galveston.
She's not here, right? So you're gonna have to reset this till we get her back.
Till we get
All
her
right,
back.
please reset for the appearance. And how long do you think? 2 to 3 weeks, Lacey? To get.
Gonna have to get with the sheriff's office to see what.
All right, to be determined. Daniel Harvey. This other one on groups. All right. Is this a disposition without they're all trials? All right, it'll be, yeah, okay. What we're gonna do is do that on a Gertz docket.
Yes, sir.
Corey Hillman. On, hold on. Sir. Whatever. I want you to sit in there. We're gonna test you to make sure that you're sober, okay? He's charged with crime.
from Mr. Gertz on the first page.
Corey Hill.
No, do you want me to approach whether you're done?
Yeah, let me know. I'm almost through and I'll come back.
Okay.
Corey Hillman. Corey Hillman. Once, twice, no answer in the courtroom. I asked the bailiff to call into the hall for Corey Hillman in 24 CR 1242. Please.
She's talking about that one. Yeah, so you have no, that's all. Gotcha. Leave this phone, try to.
No answer to that name being called in the courtroom. No answer to the name being called into the hall. Defendant's bond is revoked. The warrant is issued for his arrest. No bond, since this is trial docket day. Hold on, John. You're still.
Oh, I got them.
Aaron Trailer. 4 cases. Aaron Trailer. Aaron Trailer, no answer in the courtroom. I ask the bailiff to call into the hall for Aaron Trailer, please.
Yeah.
Hey, you talk to me. You're charged with illegal possession of a controlled substance. As a condition, you want to be held in contempt of court right now for interrupting the court? Mr. Rude, don't speak when I'm speaking. The lady here can't take everything down. You're charged with a serious felony offense. And as a condition of your bond, you can be drug tested at any time. You did read those conditions of bond, didn't you? Well, you would know if you did.
No response.
No response. Defendant's bond is revoked in each of these 4 cases. No bonds, because this is the trial docket. A warrant is issued for his arrest on each case. David Medina. David Medina is called. Please come forward. Charlie. Oh. Yes.
Judge, I'm not ready, Judge. I was getting hired last month and I didn't realize it was on the trial docket. I mean, I understand
It's over a year
I
old.
understand it's over, but
Well, I mean, that's waiting to the last minute we're on the trial docket, either ready or not.
then I'll do this.
Y'all talked about it. Where are we headed?
Judge, I think, I don't see it really being a trial. I haven't got into it deep enough yet to know for sure.
And once again, it's the see the problems with this is we got victims who say, "What the heck? How long does it take?" And this says it's serious bodily injury occurred in this. So with the Victims' Rights Act, we got to move on after a year and a half, 432 days time. You're on the trial docket. You're on the trial docket, and it's in its slot. It'll be in the back. You're in the slot. At this time, y'all got to be ready to move forward.
Yes.
And then finally, Trevante Moten, please, Mr. Lewis.
Which? That was a fees note.
It's ready.
All right. Let's take Mr. Moten on Marvin's cases, please. Let's get these things out. So we'll know. And then the rest are going to
Be the
get.
very last one.
All right. It's Mark.
The deadly conduct, this one he's pleading to, we're getting rid of the rest of it. Yeah.
We now call 22-39866, the state of Texas versus Trevante Marquise Moten. You're Mr. Moten. Present with Mr. Lewis, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does only key.
In summary, this indictment alleges that on or about November 8th, 2021 in Jefferson County, Texas, you committed the 3rd-degree felony of deadly conduct. Do you understand what you're charged with here? And that was knowingly discharging a firearm at or in the direction of a person. Okay, a third degree felony means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable here, sir? Yes. Martin, you had trouble with this tablet too. We're getting replacements, thank God. These things are worn out of something. Can't touch them without smudging, and then it marks all over them. An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $1,000. You do well on probation, your probation term is cut into 1/3 of it. You're going to do well, right? If I follow this agreement, you have no right of appeal of your case. Do you understand? Have you pleaded to sir guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Yes, I'm going to show you what's marked as States Exhibit 1 here. Did you sign this document voluntarily? Understand it, discuss it with your attorney. Put the phone up. Good Lord. You can't follow any of the rules. Sir, there's a sign that says don't bring cell phones in the room. That's where you're sitting over there. You can't follow any of these. What are they showing us? For him. What are they showing up for him? He needs to be tested. He's got problems.
I'm not sure.
Call him up.
Yeah.
Probation?
Justin.
Get somebody over here, please. Thank you. Thank you.
He's on his way.
He's on his way. All right. How do you plead to this again? Are you pleading guilty voluntarily and because you are guilty? Okay. I'm showing you what's marked as States Exhibit 1 here. Did you sign that document? Yes. Understand it? Discuss it with your attorney? Are the contents all true and correct? States Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All three, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is away here. Yes. I'm going to follow this agreement, sir, with nothing further to add. I'm going to find today you are pleading guilty voluntarily to this third degree felony of deadly conduct. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding with postpone so long as you follow these terms and conditions of probation, which are the terms and conditions of life I follow. All of us follow. Don't get in trouble, and you will be fine. The probation officer is going to go over all of these. You will be fined $1,000, which you pay over time, and make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. And you've never been arrested before, have you? I don't see anything. You don't have any convictions. Okay. Yeah. This is 8 years, not 10. 8 years. So in a 30-year time, it'll be less than 3 1/3. Okay, follow those and you'll be fine. Okay, please see the probation. Hey, Marlon, be careful of that. Okay.
Judge, may I approve?
Man, this thing is slow today. One of them side is on the feet. On these dismissals, can you automatically dismiss them? Yes. For me, thank you. Because there's a bunch of them. Yeah. Who cares? Yeah, here's this one's okay, Jeremy Robertson, Tom.
Seems to be fingerprinted.
Okay. I think I may have given you that. Jeremy?
Yes, sir.
I need a fingerprint. Please.
It means I'll people every day. Doing that sentence.
That's it's just third one. Tom says it was dismissed.
Are you sure you're business?
Yeah. Oh, yeah.
Do.
Oh, you had it all the time, yeah.
Mr. Robertson, I need to do the stuff over here.
Over here, thank you, thanks, Jeremy.
Mr. Right hand is where I want from you. Your right hand, Chris. I need to go. She just gonna find out.
That was gonna be a problem.
I don't know yet. I have loads.
21-38145 is called Jeremy Joshua Robertson. That's you, sir. Present with Mr. Burbank, you attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
He does, your mayor.
In summary, this indictment alleges that on or about July 24th, 2021 in Jefferson County, Texas, you committed the second degree felony of aggravated assault. Do you understand what you're charged with here, sir?
Yes, sir.
You've not been in trouble before, have you, Judge? Yes, sir. Now this is fixable. Fixable. Let's move on with your lives. Just everybody makes a mistake from time to time. It's just how you fix it.
Okay.
A second degree felony means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes. An agreement has been reached in your case, and you would be pleading guilty, placed on deferred or unadjudicated probation. Is this 400? Fine of $400. That's odd.
It's unusual.
It isn't the four that I recognize in the Arabic numbering system that we've used for years.
We asked that the probation for the license.
And there will be terms and conditions of probation which are normal and customary for this service. It can be up to 10 years in length. Do you understand this? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty?
Guilty, sir.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty.
Yes, sir.
We have a problem in there. You can get some more. We're going to have a problem.
There's two back there already now, Judge.
All right. To show you what's marked as State's Exhibit 1, did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1, tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report as well.
Yes, if you will.
I'm going to follow this agreement.
We would ask for consideration of less than 10. We know it's too difficult to support. He does not have a record.
And Huh? All right, this, okay, I'm reading this, and according to this, it states that the defendant, there was some kind of a problem. There's a security guard arguing with the defendant at a lounge.
It was that.
Hold on, let me read this and y'all can do. The defendant pulls gun out, points it at the complainant, pulls the trigger, the gun malfunctioned. And so the difference between murder and what we have here is a malfunctioning gun.
Well, that's kind of the contention we have. It's not that he didn't pull the gun out, which is basic to germane to the charge, Judge. It's whether or not it was actually trigger was pulled. But
yeah, but that's what's in the indictment.
Well, that was in the indictment, but
it says pulling the trigger, and then in there using exhibit. Well, is he guilty or not?
Yes, he's guilty of that.
Well, it's going to be 10. I mean, let's just thank God that there wasn't a murder. Then when you pull a gun out and point it, I mean, the complainant can only think one thing. His life is the end of his life is a clock's tick away. But could have been worse.
Yes, sir.
I find that there is sufficient evidence supporting this guilty plea to find you guilty beyond a reasonable doubt, but I'm going to defer any finding of guilt. Place you on deferred or unadjudicated probation for 10 years. You do well, it'll be shortened at 3 1/8, and you will not have a conviction. There will be terms and conditions of probation, which are normal and customary for this type of offense. Please make sure you follow them. There's a fine of, was it 400 on it?
Yes, Your Honor. Just one other thing.
Well, this says 500, but y'all said 4, right? It was kind of, I looked at it and it was weird, but it's showing 4.
400. I can say 4. No, I'm on our page. That's okay. Let's push the stick. Okay.
That's an odd number, but that's what it was showing.
Yes, sir.
But then again, there's a lot of odd going on in this room. You know, so we are not conventional.
It's a strange one.
This is not a conventional room.
Mr. Robertson is also requesting, Judge, I think now that he can have his ankle monitor removed because he's out for.
Sure. Yes. Okay. Great. That's kind of an inconvenience to say the least, isn't it? You get used to it like a friend, but then again, it's time to part.
Yes.
There comes a time when it's time to part.
It would be excused.
Yes.
Yeah.
Yolanda Martin? We'll wait until he does. He's in custody until he does. Okay. That's applicable in all cases. Yolanda Martin, please, on John West. Where's John?
Judge, man had to run to another court. No.
John taking care of, yeah, I see. William there's taking care of John. Okay, hold on, ma'am. We'll wait until he gets here. Okay, thank you. Justin Berry? Brian?
Now.
Oh, it's Brian. It's Kevin.
Yes.
You doing Brian stuff?
Yes, Your Honor.
Here, Judge.
Thanks, Justin. Okay.
Yeah.
You know, speak to three?
Yes, Your Honor.
All three. It's all three. Let's do it numerically. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
We can, Your Honor.
In summary, 23 CR 1437, sir, states, and you were Justin Keith Berry. Here with Mr. Lane, your attorney and the state's attorney.
And Your Honor, just for that point, we're standing in for my brother, Ryan Lane, with the consent of Mr. Berry, is that correct?
Yes, sir. You're still a licensed attorney.
I am. 29 years.
Yeah, and you don't object to Kevin being here on behalf of Brian Lane. Kevin. You're very good lawyers. All right, in summary, this indictment alleges that on or about April 12, 2023 in Jefferson County, Texas, you committed a third-degree felony of theft of property involving more than $30,000 and less than $150,000. It's like a GMC automobile. Do you understand what you're charged with here, sir?
Yes, sir. Yes, Your Honor. It was a U-Haul, I believe, so that's the.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. All the smudges go out. Can't touch this thing.
Yeah, sorry.
That's why I use this thing to prevent my palm. An agreement's been reached where we be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Restitution is ordered in the amount of $1,500. There will be terms and conditions of probation normally customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily and because you are guilty.
Yes, sir.
We now go to 24 COS 54. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
He does, Your Honor.
In summary, this indictment alleges that on or about July 6, 2023 in Jefferson County, Texas, you committed the first degree felony of illegal possession of methamphetamine. Do you understand what you're charged with here?
Yes, Your Honor.
First degree felony means you are facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this indictment, guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily and because you are guilty?
Yes, Your Honor.
I'm not saying that, but it's her act, so, you know, she's pretty adamant. But, you know, they're not. You do some to understand, but you are, no, I'm not saying somebody was not doing. I'm gonna do that.
Done. Finally, 24 CR 55 is called State of Texas versus Justin Berry. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does, Your Honor.
In summary, this indictment alleges on or about July 6, 2023 in Jefferson County, Texas, you committed a first-degree felony because of possession of a controlled substance, namely cocaine. Do you understand what you're charged with here?
Yes, sir.
Same punishment range as before. First-degree felony applies. That means you are facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor. All right.
Agreement's been reached in your case. You would be pleaded based on deferred or unadjudicated probation for up to 10 years in length. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal.
Yes, sir.
Have you pleaded this case guilty or not guilty?
Guilty, Your Honor.
You're pleading guilty voluntarily and because you are guilty.
Yes, Your Honor.
In each of these cases, I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true, correct?
Correct, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted in each case. This states you are mentally competent to enter your guilty pleas in each of these cases, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, read them. You were guilty of the crimes charged and any lesser included offenses. You were giving up your rights to your jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the help that your attorney has provided to you in each of these cases. All of this is treat safe, so help you God.
Yes, Your Honor.
State's Exhibit 1 made a part of the record in each case. Pre-sentence reports waived in each of these cases.
It is, Your Honor.
I'm going to follow these agreements if nothing further and find in each of these 3 cases, sir, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to follow this agreement. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation. You will be placed on deferred as unadjudicated probation for 10 years in each of these cases to run concurrent.
Yes, sir.
On one of these, you're going to, as to one, you must complete a theft prevention plans, which is always required in that type of offense. Involving theft. There will be moral reclamation therapy also, which are all short programs, which are good and help you make the right decisions. Make sure you follow these. Conditions of probation. If you fail, the probation could be revoked. You could then be found guilty and sentenced up to the full range of punishment. As
yes, sir.
You'll do fine. But fix this.
Yes, sir.
He had a vote to make sure they don't see him there.
Thank you. Thank you. Thank you. You're welcome. Good luck, sir. Here.
You trying to make
It's all in this announcement document.
Oh, for next, yeah, in 2 weeks, for sure. Yeah. It's one of those names that are on my list that I'm tired of seeing. It's you too, I'm sure. Good morning. Are you Adrian Housley?
Yes, ma'am.
Mr. Housley was previously in court, entered pleas of guilty to, or plea of guilty in cause number 25 DCCR 0290 to theft of property with previous convictions. It's a state jail felony. And we pleaded as, no, and there were prior offenses. And so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been in the penitentiary numerous times. So I leave it to the court's discretion whether or not it wants to place this individual on probation or in light of his history.
The underlying, what he ended up pleading to, was it a third or a second?
Second.
Second.
2 to 20 because it's so habitual.
That's what I wanted to make. Okay.
Yes, sir.
Okay.
And Judge, if I may,
Mhm.
what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself. And that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop or you just keep staying in prison. Are you still working at Dragon Products?
Yes, ma'am.
You've been, I mean, it looks like you're following through with your, is it the veteran services and Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered the plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the specialized mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of two sides to this, right? And so deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for you. Because now that 10-year cap is gone. I didn't send you to prison. So if you do your probation right, then you won't have this conviction. And if you're successful at the end, the case is dismissed and you will be able to continue living your life like you have been, it looks like, for the last 16 years or so.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you're back in court, you're found guilty, which means you have the conviction, and I have the entire range of punishment, which is up to 20 years.
Yes, ma'am.
And on paper, that's what it looks like you will deserve at that point if you don't take advantage of this. So I hope you do. I'm going to hand you the trial court certification that shows this was an agreement I followed, so you waived any right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Yes, ma'am. Thank you. God
Yes,
bless.
sir. Thank you. You too, sir. Thank you, Mr. Walker.
Thank you. Excuse me.
Yes, sir. Mr. Boudreaux, you've got David Holland. Mr. Boudreaux, you have David Holland.
We talked about the case, Judge.
Thank you, Mr. Coleman.
Morning, Judge.
Good morning.
Good morning, Judge.
Good morning.
You never responded to my calls of late.
Okay, we'll see if he's here. All right, his bond will be forfeited for non-appearance and reset at 100,000.
Thank you.
Thank you. All right, thank you, sir.
Zoe and Zoe. Policy. Thank you.
Okay. Michael White. Good morning. Are you Michael White? And Mr. White, you are on probation and cause number 23, DCCR 1117 for the third degree felony offense of driving while intoxicated, third or more. And probation sent an administrative hearing. It looks like as part of your probation, you were ordered to enter and successfully complete the safety program. And that was in order to have a scram device. When you got out of safety, it looks like you obtained the scram on April 8th, and then they notified probation that you were not meeting your financial obligations, and they terminated that, and so you don't have the scram anymore. Is that correct? So are you working? Why not? Where have you looked? What different places? Speak up, please.
Home Depot Road. Different construction company.
Okay. Has he given you notification of all of that?
He has, he also gave me an award letter from Social Security.
Okay.
He receives, I think, was it 400 dollars?
He's under review right now.
I can't hear you.
He's under review right now.
Okay. So that was just a partial disability. Okay, well, I guess an option is for him to come to the office more often to take alcohol tests there.
He is coming frequently. He's on a color code where he calls everyone, and when they call his code, he comes in and does units. He also is in the outpatient portion of safety, and they UA him frequently there as well.
But are they also doing alcohol testing?
Yes.
Okay. And everything's going okay with the
Yes, he
outpatient?
hasn't had it.
The only issue is the scram.
Yes, he's going to group meetings and all
Do you drive? Okay. So here's what I'm going to do, Mr. White, based on your income and the partial disability, I'm going to retract that order that you have a scram device. I'm going to order that you continue with the drop program, follow all of those rules. Obviously, if you test positive for anything, including alcohol, you'll be right back in here. Also, as of now, a condition of your probation, since you cannot have the scram or can't afford it, is that you do not drive. So you cannot drive any vehicle at all ever without further permission of the court. So if you get to a point where you have the ability to get a car or drive, you're gonna have to go through probation, request permission, and then I'll have to take a look at how you're doing and what I can do to make sure that I feel like everybody's safe. Does that make sense? Okay, anything else you think? All right, keep doing what you're doing. Thank you, sir. Let's see, Mr. Burbank. Ms. Coffin, you have Ashley Riggins at the sentencing.
Yes, Your Honor, she's outside today.
Ashley Riggins, it's Mr. Hoffpowers. There's not? Okay, why? What did I do?
I don't know. I haven't noticed.
Okay, I need it pulled up so that I can.
I'm sorry, Judge. I didn't realize that that's what this was. Sorry.
It's okay. I just gotta see something that tells me what to do. Usually Anna does something over there and then it comes to me here. Okay. Y'all are gonna have to give me just a minute so I can. Because also we'll need the certification. You want me to hold it for a second?
Yes, please.
Can y'all just have a seat real quick? I just so that we can get all that paperwork pulled up. You're good. Yeah, just stay in the courtroom, please. Is Mr. Comerford here?
Yes, Judge.
Good morning, sir. On Shadamon Mitchell?
Yes, I just see that paperwork.
Good, I'm signing it right now.
Okay, I'll recall it as soon as that paperwork comes through. And then, Mr. Comerford, you also have Ronnie Oliphant?
Yes, and then I have Simon Goddard as well.
Okay, are you ready to announce on Oliphant?
Yes, I'm just preparing discovery for them.
Ronnie Oliphant? Good morning, sir. You're Ronnie Oliphant, and this is 25 DCCR 0379. And what is your announcement?
I'm still reviewing the discovery with Mr. Oliphant.
Okay. Any issues, Mr. Coleman?
No, Your Honor, and we're not opposed to resit.
All right. So we'll do another about 30-day reset. Mr. Oliphant, make sure you stay in touch with Mr. Comerford so you can go over all of that information and discovery that he's received, and then we'll try to get an announcement at the next court date. All right. You're free to go. Thank you. And then Simon Gobert, you're here for Mr. Flory on that one, Mr. Comerford. Yes, thank you. That's okay. So let me print out. All right, sir, you're Simon Gobert, and this is cause number 24 DCCR 0512. Mr. Gobert's charged with attempt to commit sexual performance by a child. What is the announcement?
I'm still reviewing the discovery with Mr. Goddard.
Okay. This case is old.
It was reindicted, Your Honor. Have you got everything you need or?
Yes, I think I'm missing something, but we can talk about it.
Let me know what it is.
Okay. It looks like you substituted in, y'all substituted it just in mid-June.
Yes.
So I'll do one more reset. Get with Mr. Hoffpower. He'll work with you on whatever you don't have. And I'd like to try, even though you're fairly new on it, I'd like to get an announcement at that next court date. Make sure you stay in touch with your attorneys so that you can visit with them about everything and we'll know which direction your case is going to take at that next court date. Okay, thank you. Ms. Coffin, y'all can come back up on Ashley Riggins. I'm printing the certification. All right, ma'am, you're Ashley Riggins. And Ms. Riggins was previously in court, entered a plea of guilty to unauthorized use of a vehicle in cause number 25 DCCR 0092. The agreement was for 15 months in the state jail prison. We didn't order a pre-sentence report. Is there any reason not to go forward with sentencing today?
No.
And Ms. Riggins, have you gotten into any trouble since your last court date? Okay. Then at this time, I am going to find that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody on this case that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right, good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Coffin.
Excuse me.
Yes, ma'am, thank you.
Thank you.
See, Mr. Kimler, you have Ariana Evans. It's a sentencing. It's a sentencing on Ariana Evans. All right, ma'am, are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor. No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay,
It's not being tracked at this point.
okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right? I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do that too.
Which details, what do you want?
If I can do the 60 days that they offer me and be off of
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today,
Yes,
so.
ma'am. Okay, so I'd rather be reinstated.
Okay,
It is a misdemeanor, you know, isn't it?
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. And obviously probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, that I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued. Follow the maybe the recommendation you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an what do they call antisocial personality disorder, whatever her issues are, the mental health state.
Did you see that somewhere or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there.
Okay.
Obviously, things that can be dealt with. in therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask you to revoke her.
So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive. You were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You'll need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Can I get my phone and my system?
Talk to the bailiff of it. Just talk to the bailiff.
I need to.
Yeah, come over here and get a thumbprint, please. Here's yours. And then, Mr. Kimler, you have Raphael Glover. Mr. Nichols, this is Raphael Glover.
Yes, sir.
Sir, are you Raphael Glover? And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection on Monday, the 8th. And what is the announcement?
Your Honor, the state has tendered an offer of 5 years in this case. I've also indicated through a notice of enhancement that the punishment range will be a second degree, 2 to 20, because of a federal conviction Mr. Glover has. He's refusing the 5 years and we're asking you to continue.
So I want to make sure you understand. Are you ready?
Yes, Your Honor, stay to it.
And so, Mr. Glover, I will number your case for trial on that date. It's one of the older ones, so you need to be prepared. Talk to Mr. Kimler for trial. I also want to make sure you understand that after today, I will not accept that plea agreement. And so if you change your mind after today, you can enter a plea open to me or to some other agreement, but it's not going to be to that agreement for 5. Do you understand? And you want to go forward with your trial in 2 weeks. All right, stay in touch with Mr. Kimmler, and we'll see you back on Monday, the 8th.
Thank you.
Mitchell. Mitchell.
Mr. Kimmler, you also have Johnny Polanco. I'm ready. All right, sir, you're Johnny Polanco Senior?
Yes, ma'am.
And this is 24 DCCR 2168. Mr. Polanco's case is set for trial to begin with jury selection on Monday, September 8th. And what is the announcement?
I'm ready, Your Honor. This is the one the court will recall. And
It is.
He's not here yet.
I was mistaken, Mr. Sheriff or Mr. Smith. That the other case that he was arrested on was referred to the federal authorities. There's still been no action on that.
All right, so we'll go forward with this one.
We're ready, Your Honor.
All right, the case will be numbered for trial. Mr. Polanco, stay in touch with Mr. And there hasn't been any change with regard to negotiations or anything like that? All right, so your case will get numbered for trial for the 8th. Stay in touch with Mr. Kimmler. He'll know that trial order tomorrow after the docket and let you know when you need to be back. Okay? Uh-huh. I know I haven't seen, no, not yet. Thank you. Who's she here for? I'm just trying to, or tell me what page it's on. I'm looking. See. I just missed it. Devin Spites, let's see, see, Ms. Hawkins?
Yes, ma'am.
Good morning, Ms. Hawkins.
Good morning. Mr. Spice has not arrived yet. I spoke to him last week, not this morning.
If you'll call the name Devin Spites, please. Go ahead.
The court informed me that the bondsman made contact and said that he got a wobbly tire.
That's, yeah. You have a picture? He did let us know that the bondsman know that. It does say that he's on his way though. And so what I'll typically do is go ahead and announce the bond forfeiture. If he gets here, I'll just recall it. So if you'll just.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at 100,000. Obviously, once he gets here, I'll recall that.
Okay.
So if you'll just kind of let me know or let the bailiffs know when he gets here.
If he does not get here, how do you want me to handle the motion to withdraw? Is that electronically or?
Did you file a motion to withdraw?
I did not file.
Oh, well, then you'll need to get that filed. Yeah.
Get it filed.
Yes, ma'am. Everything's got to be e-filed.
That's what I thought.
Yes, thank you. Let's see. Mr. Comerford on Shadamon Mitchell. Thank you. And you'll get that, make sure and get that attachment emailed to the clerks today, please. All right, are you Shadamon Mitchell? And will your client waive the formal reading of the indictment?
She will.
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution.
Yes.
Okay, I'm
We're okay with.
inclined to reduce that. I'd much rather the restitution. How old are you?
25.
Okay.
We're okay.
So the restitution would be $3,999.68. Is that your understanding?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There is not.
And is there any reason not to go forward today since y'all have the restitution amount?
Judge, she doesn't have a criminal history.
All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm sorry, did you just do something? I'm seeing movement. I thought so.
I'm sorry.
That's okay. I thought she needed something on your case. All right.
I'm so sorry.
No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? So $4,000 is a lot of money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately, even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months. And all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right. I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again. I don't need to see your belly button in court.
Oh, yes, ma'am.
Okay. You're in felony court. Dress appropriately. That's important. It's time to kind of grow up. You're on a felony probation. You need to do things in an adult way, and dressing like that is not an adult way to show up to court. Okay. You need to have a seat here in the courtroom. Probation is going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay. Good luck to you, ma'am. Thank you, Mr. Comerford.
I'm ready.
That's real Crocs.
One of the pictures showed that.
Oh, I think that's what I saw was the sticky. Is Mr. Frank here? Jonathan Frank? Mr. Gallimore, you have James Rucker, 2 cases.
Good morning.
Good morning.
Judge
Judge, we are winding down on this. We got an offer since our last court date.
Okay.
It has $80,000 in restitution. So what we're asking the court is give us a little bit more time to vet that, the proof of services for that, and see if there's something that we could come up with up front to help resolve the case. I did find, I looked and couldn't find them. I did find though the proof of services for that 80,000. So we need to go through it. He has
Okay.
not seen it. That was added in discovery at a later date than when he came to my office the first time.
Okay. Any issue?
No, if you recall, when we first came in here, we were still waiting for.
Right.
Because the cleanup was still.
Right. And so y'all got everything's here and you've got it all. Okay.
The offer's been sent. We should be.
Perfect.
Done with it.
So we'll do one more reset, and Mr. Rucker, make sure you go in, visit with Mr. Galmore, go over all of that discovery so that we can figure out an announcement at your next court date, which direction your case is going to take. Okay? All right. Thank you. Mr. Lewis, you have Paul McCorvey.
Yes, ma'am, Judge. Mr. McCurry called my office this morning, but I haven't seen him this morning.
If you'll call the name Paul McCorvey, please. Oh, but he did call here as well.
Did he? Okay.
But he was coming just late. Is that what?
That was on street, can't memorize.
Okay.
Mr. Sean is past vacant.
Good.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at 100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Kira's aunt, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone. So I'm assuming he is trying.
Maybe on his way. Okay, thank you. And then you've got Kira's Antoine, Mr. Lewis.
Yes, ma'am, Judge.
Are we? Okay. You're Kira's Antoine, and this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge, and we contacted them this past week asking for an update. They hadn't gotten back with us yet. I even
Okay,
had Mr. Hoppower call because he's used to dealing with them.
right.
And he did that for me at the end of the week and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to him by email. Stephanie,
Okay.
But we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me an
expect them?
update, But it was Friday. when
Okay.
I got last contact.
She's usually pretty responsive. All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you. Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoppower's voicemail. Sound about right? 2 minutes, hopefully.
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
You can handle it.
Next game.
Mr. Rojas, you've got Carnell Beard. Morning, Mr. Rojas.
Morning.
Good morning, sir. Are you Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Are we going on count one? Oh, no.
No, ma'am.
Okay,
Everything.
okay, let me, All right, and he'll waive the formal reading of the indictment. Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge,
do we just need to go on one, or
Let's
is
just
that?
go on one because I'm looking at the dates and they do overlap, so it would not make them.
It wouldn't, so it makes it a second-degree felony.
Your Honor.
So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine and there would be restitution ordered as determined between now and when we come back for pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced, but
1599 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have, since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count 1 only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement, unless there is new information that your attorney or the district attorney's office receives. Do you understand? Okay. If you'll just have a seat, she'll call you up in just a minute. Mr. West, do you have Michelle Johnston? Good morning. Michelle Johnston. Good morning. Are you Michelle Johnston? And Ms., this is 23 DCCR 2260. What is the announcement?
Your Honor, me and Mr. Coleman have been talking. We have an offer on the table for some restitution to be paid. My client has indicated she needs some time to come up with that. So we'd ask the court for as much time possible to come up with that money. She's recently served some time in federal prison, so she has lost a lot and has filed bankruptcy. So is having some financial problems. So,
well, the case is already 600 days old.
I know, Your Honor. Most of that was taken out while she was in federal custody. So.
Judge, I didn't know we talked about the federal custody, but I didn't snap to that possibly being another avenue for us to resolve this case. Can we put this case on recall, Judge?
Yeah, let me hold it for a minute.
Okay, sure.
Okay. Ms. Holmes, you have Nakia Brandon?
Yes, Your Honor.
This one for drug patch, just put on docket for drug patch issues.
Oh.
I think Anna had sent some emails out last week.
Yes. So I'll get a test this morning. Good morning, you're Nakia Brandon. So, Mr. Brandon, you're ordered to have a drug patch, and it looks like you've had some issues with that. Have a seat in the jury box. We're going to get you tested this morning. TJ Landry, looks like that's set for a plea.
I had a motion to withdraw last week. Yeah. He's been having a lot of financial difficulties.
Hold on. All right, this is 24 DCCR 0165, your TJ Landry. And this.
If you need me to move it, I'll move it. But I've been patient with Mr. Landry to, fulfill his financial obligations, and he just.
Are you working?
I'm working. It's the hour. Let's see. I was out for like 2 weeks because for this one car. The money I have for her, pay her, I used to get my car going. I'm trying to fix it. That's all I'm trying to fix now. I ended up calling her ahead of time and told her, hey, I got my money to make the payment. I called her ahead of time. And then I ended up going to jail for expired registration tag on my car. So I had to pay for my title fee transfer.
The thing is, if he qualifies, it's going to be you because you were initially appointed, which isn't super fair. I understand. Y'all have something worked out?
There's an agreement for probation. I think the state is asking for straight. We're asking for deferred.
Okay.
I'll get the paperwork.
Yeah, it's going to be either way. I don't, on this one, just because where are you working?
ExxonMobil right now. I just got this one.
When did you just get back to work?
Thursday last week.
When is your next payday?
Thursday. You get paid every Thursday.
What I'm inclined to do is, even though it's been going on, is reset at one time to give him some time to take care of some of the obligation to you, Ms. Holmes, and then we'll take care of it at the next court date.
Yes, ma'am.
I should be okay because I
You need to take care of Ms. Holmes. She's been working on your case very hard. And so it sounds like she's got a good offer for you. And now that you're working and you're working full time, I would expect you to hire someone. You've done that. You need to try to take care of that obligation. I'm going to reset it 30 days. I want you to get with her, take care of as much as you can with her, and then we'll take care of it at the next court date.
Yes, ma'am. Thank
Okay.
you.
Thank you.
Thank you, Judge.
Edmund A. Latulis, Ms. Holmes?
Yes, ma'am.
Maybe that'll help.
Yeah, thank you. Thank you. Yes, I'll call you. Okay.
All right, you're Edmund A. Latulis, and this is 24 DCCR 2057. Ms. Latulis is charged with abandoning or endangering a child, and what is the announcement?
Yes, Your Honor. So there's a co-defendant involved. Spoke with Mr. Hoffpower. He would like to meet with both me and the co-defendant's counsel.
Which I spoke to Mr. Burbank, who's here.
Okay,
Like, if you want to hold off on our announcement and make sure that we're doing that, but I think we have a resolution, but due to the nature of the facts of this case, which is a dead child, that's why I want to make sure we cross
right.
every I.
Well, and this one was, I have a notation that this one was going to go before the other one
Right.
anyway.
Right.
Oh, I didn't know that.
She needs to talk to her client about what our offer is in regards to.
Yeah, I was
Right.
getting offered this morning.
Oh, okay.
Right. Now we've spoken.
Okay, so let me do this. I'm going to reset it, just a normal reset.
Okay.
That way you can go over any options with Ms. Latulis. Y'all get together, Mr. Burbank, Mr. Hoffbauer, y'all have 30 days to take care of all of that. And I want an announcement at that next court
Yes,
date.
ma'am.
Okay.
Okay.
All right, Ms. Latulis, stay in touch with Ms. Holmes because you're going to need to go visit with her before the next court date. And then Zoe Valencia, Valicilla.
I want to, oh Lord, she signed on the wrong line.
Oh, that's okay.
Is that okay? Okay. I'm sorry, Lou. She had signed on the wrong line.
Okay.
Sorry.
Good morning. Are you Zoe Valicilla? And Ms. Holmes, will your client waive the formal reading of the
She
indictment?
will, Your Honor, and I'll email the attachment.
Oh, thank you. And Ms. Valicilla, in cause number 24 DCCR 1364, you're charged with a second-degree felony offense of burglary of a habitation from May 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 7 years in prison. And what that means is that you're leaving your punishment up to me. And as long as I don't give you more than 7, you're waiving any right to appeal. I can give you 7, I can give you less. It'll all depend on the information that's brought to me when we have a sentencing hearing. You have every right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Valicilla is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get with Ms. Holmes and get that information to her. She'll present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Zachary Turner.
See Mr. Frank. You see Mr. Frank?
I bet you he has a no-show before and he never got a motion to withdraw.
Is DeAndre Smith here?
I'm sorry.
DeAndre Smith, will you see if they're here, please?
Just come into work and show them who you are. So wait till the warrant.
Bless you.
Here before you come back on the state, okay? Sign right here and put your docket. But again, wait till the warrant calls.
Crazy, John.
Good morning. You talked to your attorney?
Yes, ma'am. He's texting like 30.
Oh, he is coming?
Yes, ma'am.
Okay.
I had talked to him. He said he had talked to the DA also.
Okay, if you just hang out till he gets here, okay?
Yes, ma'am.
All right, thanks. No, it's fine. It's not even 10:15 yet. Mr. Burbank, you've got Andrew Jackson.
Your Honor, we have a deal
Okay,
with one caveat.
okay.
Yeah,
I know yes.
Take a deep breath. He is going to plead today and it's for 12 years.
Uh-huh.
The girl wants to come and make a statement if we can reset it for 30 days or whatever it is.
We'll reset it for 1 week.
That's fine.
It's been reset enough. We'll do it on Tuesday on a jail docket. We've got jail here anyway.
He just needs to take care of some stuff.
He's got a week.
Yeah, that's what I'm
Yeah,
saying.
1 week.
Because
It's not like this is a surprise.
No.
It's not. So
Yeah,
you had 30 days to take care of this and time to get them here. So obviously, everybody knows this is a bit frustrating, get the paperwork done.
But we're doing it right now.
And it will be 1 week to next Tuesday. Okay, all right.
He's going to take a plea now.
Okay, yeah, you get that paperwork done.
You'll have to see your picture.
Thank you.
And I have a Mr. Martin.
Do you?
John Martin. I did, but that's not.
Yep. John, he said. Mr. Kelly, you've got Raymond Ryder.
He's present.
Good morning, you're Raymond Ryder, and this is 23-41597. Mr. Ryder's case is set for trial to begin with jury selection on Monday, the 8th, and what is the announcement? All right, obviously, this is quite old, so it's likely to be numbered at the top. Any changes with regard to negotiations or rejections that I need to go over? Hey, can y'all hold it down? All right, so Mr. Ryder, stay in touch with Mr. Kelly. He'll know tomorrow after my docket what the trial order is, but expect to be here on Monday, the 8th for trial, okay? All right, thank you.
Thank you, Judge.
Is it okay if I need to do a plea, make sure we're waiting? I don't think they've come to drug testing
Oh,
yet.
yeah, sure.
Okay, I'll be right
Yeah,
back.
just let me know when you get back. You're good. Ms. Hawkins, did your client get here?
No, ma'am.
Not yet, okay.
I did follow to the drop, he didn't pull it from my iPad.
Oh, you filed it
I
today?
just did it.
Okay.
Probably don't see it yet.
It will probably be tomorrow
Okay.
because of the system. And you've got to give him notice of that as well. So we'll see if he shows up, but if he'll agree to it, I possibly can get that done today. If not, technically he's got to have notice. And so we would have to reset it for another date, but let's see if he gets here first. Okay, thanks. And, Mr. West and Mr. Are y'all
Still working on.
Okay, thank you.
County Court of Law 2, 1999, 92, 92, 93, 94, 96, 99, 2003, 2007, 10, and rounding out 2013. Your attorney has gone over all of this with you? Yes. Yes. Okay. Paragraphs 1 and 2 constitute a state jail felony. So that means that you're facing no less than 180 days up to 2 years in the state jail and a fine not to exceed $10,000. What's this?
Class A misdemeanor.
With 16 convictions?
Can we talk to you on term and always maker? Because you told us to do that. If we got something special to talk about.
You
said he was running that, I didn't know if you wanted to number it or what.
Trailer, that is, how many did I send to Baylor?
It's Templeton, you've sent 3 so far, Judge.
Okay, what did I send to Baylor Wortham, the Judge Wortham?
Doesn't have any-
As he said, I thought he said he was gonna do 1 this week.
No, he doesn't have a panel this week. That's why she's the dates. Not panel, something.
Okay, well, here's what we're gonna do is, yes, this is a trial for sure.
Aaron Tyler, yeah, sure.
Okay.
Have Aaron Tyler.
So that number 2 here. Judge.
Aaron Tyler, huh?
We don't have a number 2 here. I'm gonna set a number 2 here. Okay.
I thought Sean Broussard was 2. I'll meet you right outside. Okay, that's in Templeton?
You sent me over to something.
That's right, Sarah's in there. Okay, you're number 2 here.
2 here, okay. I'll be back at 1:30 on that. Well, you're right now.
And just and what we may end up, if you don't go, I may end up sending you to Judge Wortham on September 15th as a special set.
It's not on me too. But I do have to run.
Okay.
I do have to run the drug police, take care of something. I'll be back for a long docket.
Is that it?
Yeah, Mother did not show up.
Okay, Brittany, you ready?
Yeah, sure. We have an agreement. I'm just waiting to get a
Joshua?
tablet. Yes, sir. He's here.
You waiting on a tab?
Yes, sir.
It's voting up to. Excuse me. Sweat, I'm a little watch the tree. Used to be waiting on the little green line to go across the river. Good news. This is into that so long. On Mr. Grove's cases, let's see, we've got Templeton, Ernest Thomas is going there, right? And then I've got Owens and then Aretha Jackson.
That's the plea, Judge, as soon as I get it filled out.
Okay. Yes.
And that's Judge Templeton and what time wins.
Yeah. And I do have David Medina. I can send also to Baylor Wortham, Judge Wortham, on the 29th.
Okay.
That's
it.
Yeah. Sure, it's Charlie Rojas.
What am I getting to the 29th?
Okay, Mr. Harvey, who is your attorney?
I'll be back.
Yeah, where's?
Here. He's in Orange County.
I know, but his assistant is Miss Minaldi needs to be here. No, call her out. We gotta deal with something. She back there? Thank you. Here, let's see if that's covered. I think that got it covered. I think all of this is covered. I don't think I'm missing anything. Mhm. Good, Father.
Yeah, Mr. Harvest.
Hello, come on up, sir. We drug tested and he failed. He's got THC marijuana positive in his system on the trial docket day. Your bonds are revoked and you're taken into custody, Mr. Harvey, no bond, because this is trial docket day at this time. And was there anything, Mr. Gerg tell you what is a backup plan in the event, but this was a trial, right?
Yes.
Okay. All right. It's set for the next trial docket and no bond. He's failed to follow his conditions of bond and tested positive for drugs. That is all. Thank you.
Yeah, he's still married.
And Robertson, Jeremy Robertson, who am I waiting on that?
Red dot on the carpet.
Where did you go? That was a plea, Judge.
Okay, I didn't mark it off. And I've got all those dismissals. You're going to take care of them for me. Thank you. Jesse Maddox.
Great, Judge. Well, you wouldn't say something. You could do anything.
What are we doing on that?
I'm sorry. He's failure to register. I'll give him everything. He insists on running dogs.
Okay, I'm going to need
Take a look at.
announcement docket files.
Yes, sir. Do you want the whole stack or one at?
A little at a time.
Okay.
No, I'm just solving.
No one's new. Come on, Mr. Maddox.
25 CR 463 is called Jesse Lynn Maddox. That's you?
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. You were charged here with a second-degree felony of failing to comply with sex offender registration, which is based upon a conviction of indecency with a child that you acquired in the past. And also paragraph 2 goes on to allege that in 2022, in the court next door, you were convicted as well of failing to comply with sex offender registration. So what this means is this second degree felony of failing to comply with sex offender registration, if paragraph 2 is proven true, you're looking at that you have a prior conviction for failing to comply with sex offender registration in the court next door in that clause number 22-40061. You were looking at first degree felony punishment. No less than 5 nor more than life imprisonment. Do you understand what you're facing here?
This here was supposed to have been dropped when I went last time.
It's not dropped, sir. The state's moving forward with it. And this states that this occurred on or about February 26th earlier this year. And that's another offense, a separate offense. You've got to pay a price. You don't, every individual mistake that's a crime has its own consequences. You understand what you're facing here? All right. All right. Did you want to put something in on?
Yeah, I'll put a record.
Go ahead.
Just for the record, I did give him Mr. Ham's offer of 4 years TDC. I also gave him the police report. I also gave him his indictment with discovery, and it was his decision. Can you tell me you're going to try?
It'll take you 4 years.
Are you going to take it now?
We'll get, man, I can't come over, handcuffs on, down handcuffs.
Judge, I signed him up and he said he's going to take it now. Back there, he told me no, he wasn't going to take it.
Well, the more information he gets, the more wiser his choice is. That's where everybody can change their mind if they get more information.
That's cool. Judge, if you don't mind, can I set him up right now? And I can move the case today. So you are going to take my already.
Yeah, can somebody do these things? They're still tightening up. I can't even.
It's, I'm not in control of that. The executive branch, the sheriff is. We're going to take them. Whatever it takes for you to be able to sign is what we'll fix. Okay. Talk to the lady.
Okay.
Oh, thank you.
I'll find him up, Judge. Thanks.
Tom Burbank.
Hey,
Eddie, is Eddie Davis here? Mr. Davis? Hey, let me ask you, are these people on bond?
He's a jail, brother.
This is the jail docket.
Hey. Montreal Lifestyle. That's it's okay. Ben Jeffries. We got to you. Good. Reagan, you're next. She's not here. Ashley Nelson.
Yes, Your Honor. We've submitted a motion for a competency evaluation.
Just that fine.
Yes, sir.
It's just what happens.
Two of them.
Yes.
Do we need her out or is it him?
It's a.
Yeah, let me just, let's get Miss Nelson.
Need items and documentation saying that she's currently receiving Social Security for mental health issues. But believe that.
Who are you, ma'am?
Mr. Nelson.
Okay, you are charged with two cases here, it looks like, in cause number 24 CL 1985. It looks like obstruction or retaliation. Let's see. You intentionally or knowingly threaten to harm another person, a Stephen Nelson. to prevent the delay of service of Stephen Nelson, a person who had reported the occurrence of a crime. And that carries with it up to 10 years in prison if convicted. Do you understand what you're charged with here?
Yes.
And in this is and 24 CR 1986. That is also another obstruction they get charged, alleging on that same day that you knowingly threatened Belinda Nielsen. So each of these cases, you're looking at up to 10 years in prison for if convicted. Do you understand? Serious?
Yeah.
All right. And in this case, Mr. Jeffries is your attorney. And I'm looking at a motion that's been filed for competency examination. It says, okay, the fact that she might be on disability or mental health related issues, what is it we're articulating that needs we have evidence that she may be incompetent or possibly insane interactions. I don't know. And struggle to communicate coherent information related to a situation. Every lawyer says that. What is it that's unique here that gives me the option that we should get a licensed psychiatrist? I mean, these are just general allegations. We have to specify and articulate something so that, because everybody can file this motion and be out of money in a day and a half for competency evaluations. What's unique about her situation that needs this, other than just general statements? These are just conclusions. They're just not articulating something or that is unique to her.
Well, I don't know.
Because she's on MR disability, that doesn't do it. And that's not enough information for me.
It's just a lot of things where I really can't speak about that. I mean, visually, you can see, I've been tortured.
Say that again.
I've been tortured.
Who's tortured?
Everyone just looks like this for.
Yeah, who's been
Well, I mean, I thought this was 20 years ago. I mean, I just woke up in a hospital. I don't remember a house fire. I don't think I was gonna try to put a house fire out, with my hands, and I just walked out to my door. I woke up, with people mocking me and stuff. I mean, that's how I keep my mouth shut. I don't like getting hurt. And so I don't want that to ever happen again. So I just kind of been taking whatever I can to get by the day. That's me. That's mine. I don't believe it's a lot of things I just can't really. But yeah, I didn't do right. I knew I shouldn't have been over there, but I just don't want to be around these people.
Which people would that be?
Same people out of
The Nelsons?
At the hospital mocking me, and
Who were the Nelsons? Do you remember
that's
that?
allegedly not counting. I mean,
But they're not
just, know I know I did wrong. If I can just say that I'm a letter from Social Security saying that I can take care of all money, maybe privilege can kind of help me, get on my own feet or whatever. I kind of have a plan, I can move in that federal area. I just want to be away from those people. They're not.
Do you live with them?
No, I've been in a hotel since COVID with my 2 dogs. And
Well, how do you interact with them? What situation is it that you have to be?
it's been like kind of abandoned in a hotel, 2 dogs since COVID.
And Your Honor, I would just note that I have spoken with the complainants or the mother and father of the defendant, and they are also
That's
concerned.
who Stephen Nelson is?
Yes, Your Honor.
And Brendan, is it Brendan? Belinda, so they're your parents.
I'll settle there.
Who's your natural parents?
My mom, she passed away, and she was 42 when she passed.
Well, she young. What happened?
She died of pneumonia.
Oh,
Yeah, she
terrible.
had a drug problem.
How old were you when that happened? Yes, no. Well, I remember that.
Yeah, they're divorced across the world, but I just don't want to be around all those people, man. I haven't been, that kind of allowing dogs, but I don't thought the was going to have stable. No, I shouldn't have been over there. I just didn't want to get hurt or hurt each other. I really don't want to hurt anyone. Whatever I taken it. I don't want to hurt him. I want the best for him and I'll take what's best for me, So if I can just maybe get like a letter to Social Security saying I can take control of my own money. And then get moved if I have to do.
You receive an income, is it Social Security or something?
Yeah, that's want to be on it. Like,
Yes, ma'am.
if you need to be on it, you need to be on food. I didn't want to be on food stamps.
What other income do you have?
I'd like to have a job.
No, now.
That's
It's just Social Security solely then.
And Your Honor, we have offered a deferred. I know Mr. Jeffries just wants to make sure that,
Yeah, I understand.
evaluation.
What I've done in each of these cases is I've granted the motions, and I'm going to ask Dr. Edgar Pond, a licensed psychiatrist, to come and speak with her and evaluate her to make sure that we're not missing something that we can help her get treated, so that when we release her, that you're ready to go into the great outdoors and you're going to be able to take care of yourself without harming yourself or others. That's what's important. Dr. Rapon is going to come speak to you here. It's within a week. He is out there doing that. And then we'll get you back. I want him back in 2 weeks, so we don't languish, so she doesn't languish, especially if that's where this might proceed. But one way or the other, we want to know which direction she's going to go in quickly to move her out of the jail. Out of the jail is not helping any. I know.
That's the week of September the 8th.
I don't know. No. Is it? Yeah, I guess it is. Is it 3 weeks better?
No, sir, that works perfect. I think I'm supposed to be here for John.
Okay. All right. Then good luck to you, man. Thank you. Which reminds me of that other case that we had some last week.
Yes.
Yeah, so I want to make sure that's David Grove's case. Okay, we got a plea? Yeah, I got a plea. Come on up, little buddy. Who is it?
It's Mr. Maddox. I got it with Mr. Ham.
Yeah. Yes.
Is it
Yes. I'm gonna hang up here.
I think it's in the office. You can cheat on it.
You know what you can.
And I'll get your fingerprint.
Yep, you need to go around her next. And get fingerprinted, sir. Jesse, she needs to fingerprint you real quick. And Reagan, what are we going to do on Kendrick Franklin?
He's a plea judge.
Okay. Are you ready? on that? Okay, we'll do it right after this one. Okay, thank you.
From the trial docket, we have just Joshua Ledet ready for you at your disposal, Judge.
Wow.
Juggling a bunch of bones.
Yes, sir.
You might call me a ball juggler.
I'm not calling you that today, Your Honor.
25 DCCR 463 is now called. The State of Texas versus Jesse Lynn Maddox. You're Mr. Maddox.
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive on the formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Mr. Maddox, this indictment alleges here, we're only going on paragraph one. Paragraph one alleges that on or about February 26, 2025 in Jefferson County, Texas, you committed the second degree felony of failing to comply with sex offender duty to register. Do you understand what you're charged with there, sir?
Failure to maintain registered, yeah.
Yes.
There you go.
If convicted of a second degree felony like this, as it's alleged, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment, right? An agreement's been reached where you would be pleading guilty, sentenced to 4 years in prison, and given credit for all time you have served in accordance with this. Is that your understanding?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes.
I'm going to tell you what's marked as State's Exhibit 1.
Yes, sir.
And did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement, sir, and find that you are pleading guilty voluntarily. You are mentally competent. So you do, you have pleaded guilty voluntarily, knowingly, intelligently. There's enough evidence from State's Exhibit 1 supporting your guilty plea admitted here in this hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this charge. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years, and you will be given credit for all time served in accordance with this case that you have credit for. Do you understand what has happened today, sir?
Yes, sir.
And the other part is you got to register, make sure that you register properly. Don't get hooked on this again, okay?
Yes, sir.
And there are methods of handling that. Make sure, though, it's your responsibility to make sure that you're properly registered. And that's the first thing that needs to be done so that you don't get hit with another charge, okay?
Yes,
All right,
sir.
talk to him about how you should do that, okay?
Appreciate it.
Thank you, sir.
Thank
Good
you,
luck
Judge.
to you.
Appreciate you.
Hey, Jesse, fix this. You can do it. You can do it. You're capable.
5 murders, that's why I was going to the race.
You can do it. All right, who's next?
I believe it was me, Judge.
Yes, ma'am. Which case?
Kendrick Franklin.
Kendrick Frank? Here's one for you. Full cup of coffee I brought in, and I think I took 1 sip in 2 hours. Thank you. 25 CR 365, Kendrick Franklin. He's in custody.
Yes. And then he'll have to come fingerprint
Of course. So we've told Judge Templeton, we've alerted Judge Templeton. Do I have to? I know, but can Ellie or somebody so that he doesn't release it? I don't know when.
Then
Great.
I'll get her to bring the policy.
And thank you. I'm going to go thank him. Nice. And then Baylor, we need to alert Judge for them that he's got some coming up.
Absolutely.
Mr. Franklin, she needs to take your fingerprint, and then you can come right up here, and then we can move this case. Thank you.
Raise your right hand, please. You swear or affirm to tell the truth, yourself, you got?
Yes, ma'am.
Okay. You got your right thumbprint. Okay, place it right there. Don't roll it. Just place it. I'll take it. One more time. Right here. Right here. There you go. All right. Go here.
25 CR 365 is now called. Kendrick Franklin, that's you, sir?
Yes.
You were here with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment? And the arraignment here, can we proceed in Sunday?
Yes, Judge.
The indictment alleges here in paragraph 1 that on or about October 17th, 2024, in Jefferson County, Texas, you committed the 3rd-degree felony of assault on a public servant. Do you understand what you're charged with here?
Yes.
And we're not dealing with paragraph 2, correct?
Correct.
In fact, what are we doing here? Lesser included class A misdemeanor of assault. There is an agreement that's been reached here where you would be pleading guilty. The parties have agreed you would be pleading guilty to the lesser included class A misdemeanor assault, which is which you commit by voluntarily, intentionally or knowingly causing injury to another person, which carries with it up to 1 year in the county jail and or a fine up to $4,000 can be assessed. Do you understand what is happening here today? And this lesser included class A misdemeanor, the punishment range that is applicable?
Yes, sir.
I'll let Judge know that it just showed up.
Okay, the agreement's been reached is that you would be sentenced to confinement in the Jefferson County Jail for 300 days. Is that your understanding of the agreement? And given credit for time you have served in accordance with this.
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
And how do you plead to this class A misdemeanor again, guilty or not guilty?
Guilty,
And you are pleading guilty voluntarily and because you are guilty, correct?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You have discussed this with your attorney. You understand it fully. You were guilty of the crime charged and any lesser included offenses, such as this class A misdemeanor.
Yes, sir.
You were giving up your rights to a jury trial.
Yes, sir.
And the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, all true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is way
Yes,
here.
Judge.
I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this lesser included class A misdemeanor of assault. I now find you guilty of that misdemeanor. I'm following this agreement. You are hereby sentenced to confinement in the county jail for 300 days and given credit for all time you have served. Do you understand what has happened today, sir?
Yes, sir.
Anything else?
No, Your Honor.
That is all. Thank you. How much do you have credit for right now?
Should be around 300.
Are you about ready to leave? Huh?
Yes, sir.
Or what are you going to do?
Yes, sir.
Good. Yeah, fix this.
Yes,
You
sir.
can do it. Move on. Move on. Be the best you can be.
Yes, sir.
Yes, sir. Okay.
Thank you.
Here we go. What's this?
It's a bond forfeiture, we called off, he just showed up.
Well, whoever that is, they're put in custody. I'll deal with that later. Okay, next plea.
Nehemiah Harris.
Nehemiah Harris, 22-40151. Nehemiah Harris, please.
It's an MTRP.
MTRP, how do you spell that, man?
Give it a go.
Give it a go.
Very good.
Should have been on the other years, honestly, and.
Judge, his case is on his bench warrant, but you have to go over here, so I think that's the reason for the age.
And 22-40151 is from all the state of Texas versus Nehemiah Harris. You're with Ms. Molly, your attorney and the state's attorney. You understand, sir, there is not only a motion to revoke unadjudicated probation, but that was supplemented by a first amended motion to revoke probation filed on April 22nd, 2024. Have you had an opportunity to discuss this with your attorney, Ms. Minaldi? And are we ready to move forward today?
Yes, sure.
What happened to this deadly conduct case in Harris County and the evading arrest and detention? Is that still pending?
No,
That got disposed of?
Yes, I did meet it.
It did? Both of them?
Yes, sir.
Okay. Why'd they do that? They got the wrong guy?
Wrong guy.
How does that happen, you know? I mean, how long were you in jail?
I was in jail. I've been in jail for like 2 years.
2 years? And they got the wrong guy?
Yes, sir.
How does that get explained to you? How do you get your 2 years back of freedom? Oh, so okay. Okay. Well, there must be a lot of information that we're not aware of on that. Okay. Does the defendant waive a formal reading? Can we proceed in summary?
Yes, sure.
In summary, and raise your right hand, sir. Do you solemnly swear? You're the right hand. God bless you. Do you solemnly swear or affirm any statements you made during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Brittany, don't move. Don't leave the room. Just you're here and then you're gone like the wind. And I've called you. I keep trying to get your cases. Then
Yes, sir.
I know you're spread out. In summary, this first amended motion to revoke probation, which was filed on April 22nd of 2024, so over a year ago, I guess you've been sitting in Harris County, huh?
Yes.
Yeah. Oh, okay. And got dismissed. Do you know any background on that?
I do not, but you're pleading to allegation number 1, Judge. I think
I
you're-
understand, but that's a kind of weird. Okay. In summary, this states that on October 31st, 2022, in this court, you were placed on 5 years deferred or unadjudicated probation for unauthorized use of a motor vehicle. Was that a state jail felony?
Yes.
That's correct. It's not reading, I can't tell, but it is, everybody agree it was a state jail felony of unauthorized use of a motor vehicle. Is that true?
Yes, sir.
Which one?
Number 1.
Allegation 1 states you committed the offense of assault, family.
Do it one more time.
I don't understand what this says. Do you see that? Assault, date, / family house with weapon. What does that mean?
assault with a dating relationship or a family member
But family house?
or a household member.
You think it's just an abbreviation for household? It had to be this.
Those.
Okay, it appears to allege assault, family violence on or about September 19th, 2023 in Jefferson County, Texas. Is that true or untrue, sir? Are you pleading true to that voluntarily and because it is true?
Voluntarily, because it is true.
Yeah. Do you understand that a voluntarily and truthful plea of true to one or more violations of probation, it's enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced to no less than 180 days up to 2 years in the state jail. Do you understand?
Yes, sir.
For this underlying offense of unauthorized use of a motor vehicle. Knowing that, do you insist on pleading true to that?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement has been reached here. So where you would be, your probation would be revoked. You would be found guilty, sentenced to 18 months in the state jail. Is that your understanding of the agreement?
Yes.
And given awarded credit for all time you have served in accordance with this case.
Yes.
If I follow this agreement, you have no right of appeal of the case. Do you understand? I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct? Yes, sir. State's Exhibit 1 tendered into evidence without objection admitted. This states if I follow, among other things, State's Exhibit 1 is admitted for all purposes. This states that if I follow this agreement, you have no right of appeal. You understand? Okay. I'm going to follow this agreement. Anything else to add? If not, I'm going to make the findings that Mr. Harris, you are pleading true to allegation 1 here, this assault, family violence. You are pleading true to that voluntarily, knowingly, intelligently, as allegation 1 of in the first amended motion of revoke unadjudicated probation. There's sufficient evidence supporting your plea of true from that information provided during this hearing to find that true by a preponderance of the evidence or greater. And I now find that allegation true. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily to the underlying charge of unauthorized use of a motor vehicle. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that original plea hearing to find you guilty beyond a reasonable doubt. Because your probation is revoked, now I find you guilty beyond a reasonable doubt of that original charge. Whereas use of a motor vehicle is state jail felony. I find you guilty beyond a reasonable doubt, and I'm following this agreement. You are hereby sentenced to confinement in the state jail for 18 months, and you will be given credit for all the time you have served in accordance with this case that's applicable to that charge. Do you understand what has happened today, sir? Yes, sir. Okay. Anything else? Yes. That is all. Thank you.
Lucy, what? Did you need to do one? No, I have his print from earlier, but yeah.
Nehemiah Harris. Yeah. David Wiggins.
Judge, I have filed a motion for competency evaluation on him. Last time we were here, we discussed filing that motion. I have some stuff that
I need that filed, please. We need him out. David Wiggins, please. David Wiggins in clause number 23D CCR 1479. Okay. Mr. Wiggins? Fine. Come on up, sir. Thank you. And we now have cause number 23D CCR 1479, the state of Texas versus David, and your middle name is Sinclair. Yes, sir. Wiggins. And you were here with Ms. Manali, your attorney, and the probation officer in this case. There is a first amended motion to revoke probation that was filed May 9th of this year. And it states, among other things, that you are on probation since January of last year for obstruction or retaliation, a third-degree felony. I believe you were sentenced to 10 years in probation, and that 10 years imprisonment, that was suspended. You were placed on regular probation for 10 years. Now this motion is filed, and it states you failed to report to the probation office for a lot of months here, March, April, and May of 2024, December of 24, January and February and March of this year. When were you placed in arrest this year? Do you remember? Was it March?
I believe it's March.
Okay. So you're unable to report once you're in jail. That's a fact. You failed to report to the probation office a change of address, this states. You failed to, that's repeated twice. And then there's arrearages. So the keys were, the key items: failing to report and failing to report your change of address. The one thing you have to, the most important thing is no matter what you do, you got to report. Or if you don't report, you're not really not on probation. You're on your own probation, which kind of takes us out of the game. And we can't supervise you when we have contact with you, especially when we have thousands of probationers. Everybody's got to report. We can't go out to them. So that's the problem you're looking at here. That's why you're here. All right. What do you think? This is all fixable, you know. What have you been doing with your life since we put you on probation?
So I'm trying to stay out of trouble.
Well, that's what we all try to do. Some of the lawyers have a lot of trouble, but they're doing the best they can. But so, do you have a job and things like that?
Yeah, I've been looking.
Okay, do you think that is one of the problems?
Yeah.
Once you get something to do, you give a purpose. You have a purpose in life. Do you have a family?
Yes, sir.
Do you have children?
No, sir.
Okay. Are you married?
No, sir.
Okay. Well, those are important things you have responsibilities for when you do have children. You know. But what's your master plan when you get out?
I do a lot of YouTube. Yeah.
How's that pay you?
It depends, because if you live stream, you can actually get money by the hour.
Really?
You should look into justice.
You know, I'm on YouTube, you know.
Yeah.
Or you're not making money off of me, are you? Okay. So now I don't want to talk about these allegations, but are you having a problem with getting to the probation office or something?
Finding rides, like I really have a problem finding the rides to work. That's why I got fired.
So how do you get to work if you don't have a ride?
You just walk.
You just walk? How far is it to get to the probation office from your house?
Since I live in Port Arthur, they said it's in Beaumont.
Sir?
I live in Port Arthur. They told me it's in Beaumont.
Well, there is a Port Arthur location.
Yeah, initially supposed to go. And it's in Beaumont, but you never finished it.
Okay,
But he would have been on.
the first one, yeah.
Yes.
The main office is in Beaumont, and that's where you have to do the initial registration and all of that. Then if you're living in South County, we let you go to Port Arthur. We've got an office in Port Arthur. So where do you live in Port Arthur? Off Gulfway?
No, sir. It's I don't know the street name is that, but it's just moved in.
What's it close to?
It's Cypress Creek or something.
Okay, that's going to be probably toward Nederland, huh?
Yeah, sure.
Yeah. Yeah, well, where's the office in Port Arthur?
Up 4th Street.
Right.
Right by the GPS office. Yeah.
How far would that be, you think, from Twin City Highway and 365? No, I'm trying to think of where it is.
Just one of the other issues that we ran into last time whenever he was being saved by probation is putting that as a condition on to his probation. I don't know how much.
What is that? What do you have to do for that?
He said, I believe he's diagnosed with schizophrenia.
I know, but where does he have to go for that?
I believe in the same area, but that's the issue that we run into. It's not kept up with.
Do you know where you're supposed to go for your mental health services? Nobody ever told you? Just because he never
It's the
reports.
initial intake. That's the issue is he got probation initially and then would have to walk to Beaumont essentially to do his initial
All right,
intake.
look, I see you've got a motion here, but I think most of this can be accomplished if he
Now, yes.
if he can
Because
just.
I believe it's being kept up within the jail. This is
I
the
know,
issue
but-
we're running into, Judge.
I know, but if we release you, you have to report. You got to figure out how to do that, and it's everybody's responsibility. And then they got you on the mental health caseload, which is a good thing. But we ought to be able to take care of him if he just shows up.
Yes.
All right, all right, here.
But last time I spoke with them, we were not in the headspace to have a discussion like this, which is why I filed the motion. But now it seems that.
Well, I'd like them to analyze it and see what the issue is and let them direct me before we send him to somebody else, because I mean, he's not exhibiting manifestations of delirium or an illness. And if, David, if I released you here and we'd hold this motion in abeyance to see how you do, can you promise and confirm that you can follow these conditions of probation, report to the probation office as you need? And the first one is here in Beaumont, which can we do that? And that is that what's needed first? Okay, can we go here to the jail before he leaves and see him in jail? Can the probation office take care of that in jail? While he's in jail before he is released, because then he gets released and he goes to Port Arthur. Do you have family here?
Yes, sir.
Okay. Your family helps you move, travel?
Yeah, if she can, my mother.
Your mom?
And Your Honor, I believe this was the same problem that happened last time. It's basically the second time around. He didn't, I think you told him the same thing.
What's the problem? Look, I want him to take care of himself. But where's your mom? Where's your mom?
She's at Cypress.
Oh, no, she's not here. Okay, I thought you said she was in the room. All right. Well, look, if I released you and you failed to, first time you failed to report, you're going to come back to jail. You don't want to do that. Well, you've got to follow the rules. And we're here to help you. But that's, I don't want to hold him any more than necessary for these reasons. But if you fail the next time, it's going to be a warrant will be issued for you and you come back. And then I'm going to note in the file here that we've talked to you about it. And you assured me that you won't have a problem. Okay?
Okay.
Because I believe what you're asking for on an examination can be handled through the mental health caseload evaluation that they do. And if they sense a problem, then we can get him treatment.
He just has to.
That's funny. All right. Do you see how important this is? Because next time, I'm not just going to let you go home. We're going to have to deal with this more seriously. Yeah, you need to report to Beaumont, the Beaumont probation office, within 24 hours of your release from jail. Do you remember? You understand?
Yes, sir.
Which is here in Beaumont. You know where it is. It's not far from here. And then they're going to evaluate you, and then you're going to be reporting to the Port Arthur office regularly. If you fail, the first time you fail, I want to know about it. We're going to go arrest you, and then we're going to have to deal with it while you were in jail. I don't want that. You don't want it. Okay, let's fix this, okay? I want to review, though, in 30 days that everything is doing well. So get a resetting, and you're going to be back up here to tell me how you're doing and how this is working, okay? Because we're not going to forget about you. All right, get a resetting, and then you're going to be released. Fix it.
But he's going to be released from the jail.
Yes.
Okay.
Odwin. God bless him. John West. God bless him.
He's right.
Brittany, I know you're ready. I'm just on. Okay, come on up.
Here.
John West has got 7 pages. And he's not here.
You needed the value. I was just talking to John.
We're trying to cover for him.
Just talking to each
I
other.
can't hear myself think over the 2 lawyers talking.
Whatever. Joshua, look at it. That's you. 23 DCC R969, Joshua Christopher Ledet. You were here with Ms. Holmes, your attorney and the state's attorney does the defendant waive a formal reading of the indictment and arraignment. Can we proceed in summary?
Yes, Your Honor.
In summary, sir, this indictment alleges that on or about December 24th, Christmas Eve, you're committing a crime on Christmas Eve? You don't do that. That's a holy time. 2022. in Jefferson County, Texas. You committed a second-degree felony of aggravated assault with a deadly weapon. Probably a sin, too, as well as a crime. You understand what you're charged with? You're going to fix this. All right, this is a second-degree felony, which carries with it up to 20 years in prison. Do you understand what you're charged with in the indictment? Serious, 20 years in prison. All right. Looks like we're reducing this to the Class B misdemeanor of assault. Is that right?
Terroristic threat. State is dropping the element of the firearm, Judge.
Is it a lesser included?
It is, Judge.
What's the section on this, please?
2207.
Say that again?
I think it's 2207.
22. All the kind of ways you can commit terrorist threat. Which one is it that we're going on? 22.07 A states a person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to 1 through 6. That is a Class B misdemeanor.
That'd be number 2, Judge. Which one did you say you're on?
Says A1 is a Class B misdemeanor. A2 is a Class B misdemeanor. A1 is causing a reaction of any type to his threat by an official or volunteer agency. A2, place any person in fear of imminent serious bodily injury. An offense under that is a Class B misdemeanor, except that the offense is a Class A misdemeanor if the offense is committed against a member of the person's family or household, or otherwise constitutes family violence, or is committed against a public servant.
A2 fits the facts of the case and the indictment.
So, does everybody agree that that the lesser included offense is going to be section what people write on these things?
It's really difficult.
It's, okay, so it is once again section 22.07 subpart A subpart 2.
Yes.
Is that your understanding of the agreement? Yes, sir. If I follow this agreement, which carries with it up to 6 months in the county jail, and or a fine if we ever use Class B misdemeanor, is it $2,000?
Yes, sir.
Up to $2,000.
That's why we had to do some extra writing on your tablet, Judge, but that's correct.
Do you understand Class B misdemeanor punishment? The punishment range. Up to 6 months in the county jail and or a fine up to $2,000. Correct?
Yes, sir.
You would be pleading guilty to that, placed on deferred or unadjudicated probation for 2 years and fined $500. And you do well, at the end, it's dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. You understand?
Understood.
How do you plead to this section 22.07 subpart A subpart 2 terroristic threat under the Texas Penal Code, guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I showed you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? So the contents all true and correct.
Yes, sir.
State's Exhibit 2, I'm sorry, State's Exhibit 1 tendered into evidence without objection admitted. The state shall find you mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. And I was to go through, you read it, you were guilty of the crime charged on any lesser included offense such as this terroristic threat. You were giving up your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. And said, oh, so help you got it. Correct. State's Exhibit 1, part of the record for all purposes. Pre-sentence reports waived.
Yes, Your Honor.
You did. I'm going to follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so to this lesser included offense of terroristic threat under section 22.07 of the Texas Penal Code, subpart A, subpart 2. There is sufficient evidence from State's Exhibit 1 to support your guilty plea to find you guilty beyond a reasonable doubt of this Class B misdemeanor. However, I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 2 years.
Yes, sir.
And there's a fine of $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow this. If you fail, your probation could be revoked. You could be found guilty and you could be sentenced up to 6 months, 180 days in the county jail. You don't want that. And you don't want a conviction, even if it's a misdemeanor. So please see the probation officer right over there. Thank you. Sounds good.
All right, you were.
Yeah, Tom.
Hey, Judge.
Right. I haven't taken a breath since you left.
I thought you were.
Okay, who is it?
I thought you were turning kind of blue. I'm the girls.
Man, I'm speaking long questions, making long statements, and I'm losing my breath. Who is your?
I've got a bundle of them. I asked to be placed on all of them on the trial docket. So
there's no police in that group? I thought you had some dispositions. No?
No. Still in the discovery, but hopefully we'll be able to work it out before the first trial. Maybe not.
Are these Toms? Are these all Toms?
And Judge, I'm sorry, real quick, to the board, Mr. Ledette have his GPS removed.
Where's?
I have no objections, Judge.
Yes.
Okay, yeah. Do we need anything in writing?
Without objection, but
He's just home. Okay,
These are,
thank you.
these are first.
Eddie Davis,
Yeah, these are first settings.
20.
I don't,
Okay, we don't need it. All right.
these are first settings.
Eddie Davis
And
in
push them on.
standby in 24 CR 1553, 25 CR 65, 25 CR 362. Those are deadly conduct, discharge of a firearm, same. And then we got a murder in there. What are we going to do today?
Your Honor, I'd ask to be placed all of them on the trial docket.
All right, let's set the trial.
When I get to the trial date, we should have hopefully a disposition.
Set on the trial docket. 25 CR 456 is Najel Hopkins.
That's also murder of the judge. My understanding was he's talking to another attorney, but I'd like to place on the.
It's set on the trial docket for murder. Thank you. 25 CR 715 is Montreal Lightfoot.
That's also the same judge.
That's deadly conduct discharge.
Can I have one more resetting on that, Judge?
3rd degree felony there. 4 weeks good?
Yeah, that's fine.
All right, reset 4 weeks at request of defense. Eric Martin.
That's not to refer, Judge.
Yeah.
And that has to be placed on.
That's placed on the trial docket as well.
I think that's it, Judge.
Thank you. Done enough damage. Yeah. I wanted to see Mr. Lightfoot. I've never seen anybody, never talked to anyone whose first name is Montreal. I think it's pretty neat. Myself. You may not find it amusing, but I do. You got something, or two, yes. Who is this? Trent Nixon, I did that was. Trent Nixon. Trent Nixon, please, thank you. Where was that off of?
It's on the top. And here is the file.
Here goes the Trent Nixon, yeah, it's in both.
Nixon, write me in. Write me in where order says the whole group. Your stuff got. Okay, and ink up your right over there. Flat right here.
You're a little old. They don't, aren't you a little old for that? Yeah. To be mixing up with the kids at the elementary school and it's causing disturbances. She's in high school. It's actually college high school.
Nixon.
We now call 24 DCCR 833, the state of Texas versus Trent Sean Mixon. That's you, sir. Present with your attorney and the state's attorney, Mr. Galmore, does the defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
He does, and we may, Your Honor.
In summary, this allegation in paragraph 1 alleges that on or about July 1st, 2023 in Jefferson County, Texas, you committed the third-degree felony of voting while intoxicated. It's not the paragraph 1 that makes it third-degree felony. It's the paragraph 2 as well, which requires 2 or more prior convictions of motor vehicle or abusement. But all of these are alleging motor vehicle prior convictions. That's correct. And paragraph 2 goes on to state that you have 1, 2, 3, 4, 5 prior DWIs, motor vehicle intoxications from 1994, 97, 2013 twice, and 2017. The last one, it's the last 2 out of this criminal district court. What's the problem? We all know what the problem is, but when's it going to get fixed? And I'm asking you a rhetorical question, but can you answer? And this is far too many things. I mean, has anybody been killed?
No.
But we're lucky, right? People are exposed to serious bodily injury or death when cars crash or boats crash while intoxicated, and then everybody weeps and there's emotion, and then, but I mean, we're talking about 30 years have gone by with intoxication offenses. You're lucky to be alive, really. And it can't be healthy for you physically, much less putting everybody in harm's way. I'm railing on, but I got to tell you, I don't remember, I've done this for a long time, and I don't remember this many prior DWI kind of convictions. It can happen, but this is a rare event. So it has my attention, and everybody else. You ought to have Mothers Against Drug Driving up here and let them rail on to you a while, because they got a message to send, which is serious. At the end of the day, it's a selfish act. It's selfish. You're getting high and enjoying it, and everybody else is at risk. But 30 years have gone by, sir. Wow. I'm railing on that, but somebody's got to. I mean, that's gotta be heard. This is too many times. You're facing a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? You understand the punishment range?
You understand the punishment range? Sorry, I hadn't signed in that discovery, so.
All right, this is 2.5 times the legal limit too. Let me ask you, okay. We've had 3 criminal convictions in this court from DWIs. The last 3 convictions, 2 in 2013 and then in 2017. What does that do to, because paragraph 1, I'm sorry, subparagraphs 1 and 2 of paragraph 2 are all that's necessary to make a third-degree felony. Then we've had, I guess, 3 third-degree felonies,
2 of which will run concurrent.
I understand. Well, what does that do? Tell me what this does. If these were placed in separate paragraphs.
If those other 2 are forming the basis of that, those DWIs, that's my understanding that you can't then make them habitual if you've used those same 2 priors that were used in this one, the misdemeanors, to do that. And I believe they were used in some of the other convictions. So I don't believe that we can use those to make it habitual, Your Honor.
All 5 of those obviously are not necessary for the jurisdiction of the court. I believe they were just pled so that the state had a choice on which ones to prove up.
Yeah, but the question still stands. I mean, if I would think the 2013, the first 2000, and probably both of them are using those 2 prior convictions.
Yes.
And then the question is on 17, I don't know. I don't know what it, I don't know really what it does, but here's the agreement is that he would be placed on probation, right?
10/10 with the alcohol ankle device, the 24-hour monitoring.
Okay. Is that y'all's plan?
Yes.
Not on my watch. Nope. Nope. Let a jury decide.
That's what I'm thinking.
Not on my watch. No, sir. I believe the reason is here, I don't care what the reason is, but we've got a new DWI here. This is a 6th one. And at 30 years of drunkenness and involving yourself with a vehicle or boats. The mad people, they'll be here and they're going to want to see what goes on. Because that's not what I stand for. You've had 30 years to clean this mess up. You put people in harm's way, sir, and it's a selfish act. But you don't commit what we want. This is the 3rd felony and you get probation? I don't think so. Not for this. This is dangerous. A 4,000-pound missile or a vessel, which is going to be heavy, but a car is a 4,000-pound missile. You haven't learned in 30 years. And we're going to give you.
Have y'all met Matt Mothers in the back?
What was the last sentence he got in 2017?
6 years.
6 years in prison, and we're going down to we're going down to a regular probation.
There was a probation. With this deal 10/10 on revocation, he can get more than he received the last time. The issue here is drinking.
No, he's not going to get more. He's on probation if he gets revoked. Yeah, but what, I mean, so we're waiting for another victim or potential victims to be put. You can shake your head at 30. This is your sixth time. Yeah, so I'm going to believe that, it's not going to happen again. I'm sure you made the same promise the first time you were put on, the first time on your DWI, sir. This is a selfish act. And you can't forget the victimization and the emotion that people have in this room when people are seriously hurt or killed. Try to bring their loved ones back. But not you. This is your 30 years worth of you've been a consistent inebriate. You should have gotten this fixed the first time. This is the third time you're charged with a felony. Should have been fixed way back when. Well, there's no reason for you to be back up here. But a jury is going to make that decision, not me. Okay? Well, I reject that. We'll place it on the trial docket. That is all. I'm on. Or you don't want. Right now, what are his conditions of bond, Dustin? Did they? Because it didn't go by me, I don't believe. But does he have a
interlock device? Interlock required since his arrest.
Hold on. Hold on. He's got an interlock device. I don't want that. I don't want. What is it that we use for alcohol?
That's alcohol, interlock device.
It's an interlock device is to start. It's to ram.
That's what the plea deal was going to include.
It's going to, a bond condition is he shall have a scram device on immediately. You are going to have to put a scram device so that we know the moment you imbibe in alcohol. Do you understand, sir? That is ordered 24 hours to get that done, please, as a condition of bond. Thank you. I'm going to keep this county safe best we can. And
Jackson, I'll log in.
say that again.
Just Jackson, just I'll log in.
Where is she?
On the file, log in. The files right there.
What are we doing with that?
The plea,
With whom?
David Road.
I don't even see David.
He was just here. I told him. Oh, there.
What do we have, David? What do we have?
Well, I've got about 3 things, Judge.
Okay, who's first?
I have
Is Aretha Jackson first?
Yes, sir.
Okay, come on up. Aretha Jackson, please. Thank you.
She signed up.
24 DCCR 760, the state of Texas versus Aretha Jackson. John, don't you go anywhere. You got a bunch of cases. All right. Yeah. It looked like you were going through the door.
He was. That way, that wouldn't be worried. It's just like.
Lock the back doors, everybody.
He is not nice.
Aretha Jackson, you were charged with the second-degree felony of aggravated assault with a deadly weapon. And if you were here with Mr. Grove, your attorney does the defendant waive a formal reading of this indictment and arraignment here. Can we proceed in something?
Yes, Your Honor.
In summary, this indictment alleges that on or about February 24th, 2024 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with here?
Ridiculous.
Agreement that's been reached,
Assault class A.
that you've been charged, you would be pleading guilty to a class A misdemeanor assault, and which is intentionally, knowingly, or recklessly causing bodily injury to another, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Is that your understanding of the plan?
Yes.
we've got it on these lesser included, they've got it next to the charge. We've got to place in writing what the lesser included is next to the charge.
Well, that's a whole lot better than me trying to write it out with my Crayola hand. I don't write well and with that little space.
Agreement's been reached where you would be placed on deferred or unadjudicated probation. And was that your understanding? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as states of this Class A misdemeanor. I'm going to show you what's marked as States Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney or the confident? Among other things, you're highly competent to do so. We enter this plea. Understanding. Guidance been right here. If you get through the time chart and was completed authentic, this concept has been resolved. We get into one page of states to look at how they record confidence. It's Chairman, under non-this agreement. Which is a pleading guilty. There's sufficient evidence supporting a guilty plea from States Exhibit 1 admitted here to find guilty beyond a reasonable doubt of this offense. But that's going to be in place on deferred or unadjudicated probation. It's there. So long as you follow these terms and conditions of probation, you won't be found guilty. If you fail, your probation can be revoked. You could then be found guilty and sentenced up to 1 year of take care of this. And I don't know what everybody loses their composure from time to time. You have to focus on what you have to lose and what you have to gain by losing control. And then that gives you enough time to think about and realize there's a better way to handle this. And certainly I don't want to get myself in trouble for what somebody else might have done to provoke. Okay. Not knowing what the facts are, but always time is, you got to just step back, focus, and then you realize, this isn't worth getting upset over. Let's move on and let's not get in trouble. And there you go, ma'am.
Say the word provocation, and that's what it be.
Yes, ma'am. I know. And sometimes you just have to, I know it's hard sometimes to just, you got to be able to self-control and think, I got more to lose here. This isn't worth it. It's not worth it for whatever is this a person may have done to try to pull me into or pull me down to their level. Oh, this is going to be fixed. Please see the probation office. Okay, thank you, ma'am. Okay. What day is it? I don't even know. What's next?
Judge, I've got two cases where the court, where I filed motions for competency exam, and I believe the court considered those, sent them off for reports.
What are the cases?
Are they on the docket today?
Yeah.
What cases are they?
I don't think so. They don't.
Hey, what are we doing with that lady? Did we bring her back today? That from Friday?
No, I thought we were gonna That's which one to look like.
No,
Okay, then I misunderstood. I thought we were getting followed.
uh,
That was the information that I
yeah, no, stand by on that one. Nope. Can you pull her file, please, and let me look at it here in a little bit? Yeah.
have anything else to.
Okay, I need to look at that because I was thinking about that. I've got a change of mind on that because I made a finding and I may change that based upon Dr. Rapon's evaluation of her. And that's what I do want is evaluation, but I don't want that to be a final judgment with the time. What do I have, 10 days or 3 days? What do I have from a finding?
30 days.
30 days.
Judge.
Okay.
If this is one we talked about.
I understand. I remember, and I want him, but I want him in there to get an evaluation before I lose jurisdiction of the case. Okay. All right. What else do I have?
I think I need to file something on that, don't I?
I've already done it on my own.
Oh, well, yes, sir.
I've ordered that to be done. I just don't want it to slip through because I'm gonna forget. What else? What else? What else?
Anything else except for trials?
All right.
And this Weston was set today. He may be set Wednesday also.
It may have been reset, David.
I just got this resetting.
Now, Judge Templeton, that failing Ernest Thomas is set for Judge Templeton to trial today at 1 o'clock. And let's see what else. And then, number 2 was Anthony Owens. Judge Templeton is number 2. And that's number 2. That's in.
I'm sorry, Anthony Owens is the one that will be the plea judge.
He's pleading. I thought that was a trial.
Well, it was, but he worked out a plea.
Off across the hall, so.
All right, well then.
He can take the plea over there, I think.
No, he doesn't. I'm gonna do that. Sean Collins then becomes number 2. James Makin's case. Sean Collins then becomes number 2 in Judge Templeton, replacing Anthony Owens. Okay. What's wrong? Oh, okay. Where's Anthony Owens? Do you have everything done? All the papers on Owens?
Yes, sir. I
Okay,
do.
get him out.
He
Let's go.
is. I thought Anthony Owens was the number 1 case, and I believe he stepped out to go to lunch. We'll be back at 1 o'clock with Judge.
No, I'm taking
I understand. I misunderstood, Judge.
Ernest Thomas.
Ernest Thomas is the one that he's the one that's still out there. And I'd like to.
No, he's not out there. He's set for number 1 for the trial over there. Get out. Let's get Mr. Owens so we can get that done. He's not here?
Mr. Owens is on bond.
You're on bond. Mr. Owens, where is he?
We got released on.
I believe he's outside, Judge. He's
Okay,
on bond.
Anthony Owens. I need him. Let's get that plea done.
Hopefully he didn't go to lunch. I think he did, and I didn't have paper filled out. I do now have paper.
Judge, we're gonna have to go get the file. You asked me to send them to Temple.
No, I'm not sending him to him for the plea.
Well, I understand.
I'm gonna do the plea.
It's our understanding it was a trial, so
I know.
you can file that.
He's not.
Whenever you find him, David, he needs to come in so I can get that
Yes,
thing
sir.
done. Okay, in here, because not that Judge Templeton is not competent, but we've got all the people here to take care of a plea and do it quickly and expediently, and that's where that will be done. So again, Ernest Thomas is now 1 at Judge Templeton, and then Sean Collins will be number 2. What else?
Well, I'd like to discuss the case that is now number 1 over there, Mr. Thomas.
Why? I thought that's a trial.
Well, it is, Judge.
Okay,
but
then that's it.
again, I didn't have time to talk to the court this morning because you've been so busy.
About what? What are you talking about? What are you talking about for number 1?
About whether we're ready to go to trial.
Well, we're ready to go to trial, aren't we? it's 1,000 days old.
Yes, sir.
All right. That's,
Well, then let
it's
me
ready
tell
to
you
go to
my
trial.
announcement. I'm not sure I'm ready to go to trial on that because of the circumstance. I thought that was a number 2 case. And so it didn't matter as much because otherwise, but it's my fault, Judge. And if the court doesn't want to hear, I'm just.
No, Ernest Thomas is number 1. Right? Yeah.
Yeah.
Ernest Thomas is number 1. And
Thought it was number 2 though.
no, it's number 1. It's always been number 1. Number 2 was Anthony Owens. And yeah, and it's 1,000 days old. I mean, and it's failure to register. It takes a half a day to get ready. Come on. But that's the way it is. And everybody announced ready for trial. So that's what I did. I relied on that. That's the ruling of the court. And then we still have what on Mr. Owens, until Mr. Owens gets pled, he's number 2. Until he gets pled, and we got to get that done. But once again, he's 560 days old. And then Sean Collins was Mr. Makins, and everybody wanted trials, and that's 1. And Thomas is 1, Collins is 2 over in Judge Templeton. And then somebody needs to if Owens is going to get pled, where are the papers? Let's get them done and let's move it. Is it done in the queue?
No, sir.
We'll get them, please, if that's
Yes,
what
sir.
we're going to be doing. Okay.
Judge, I had to send Ellie for the file.
And then, let's see. I've got Medina was sent to Judge Wortham. Brittany took care of Joshua Ledette, right?
Yeah.
Yes, sir.
Aaron, so I've got Tom Kelly on Amanda Alvera, and I've got Aaron Tyler as number 2.
Correct.
I got Sean Broussard too. Is that one?
No.
What are we doing, Sean?
We can't touch on Broussard 3
Because it's
you're
Sarah.
across the hall.
Gotcha. Yeah, that was the problem.
Yes, sir. And the only other thing on the trial docket was Mr. Hillman. It's sitting in the box over there. He was a bond forfeiture, but he showed up late.
Come on up, sir. Corey Hillman. Mr. Hillman, that's you?
Yes, sir.
And your attorney is John West. Okay, let's see. Oh, it's set for jury trial.
Yes, sir.
Oh, okay. So what's what we're having?
Right, yeah.
Okay. Then where are y'all?
I'm right here, Judge.
No, have you been sent to another court? I can't remember.
No, he wasn't present at the
I
time.
meant you. I don't have to be in 2 different places.
I'm sitting with Mr. Laird on the case. It's coming up.
The end here?
Yes, sir.
Okay, that's going to be placed in this doc, on this court. Yeah, whatever. Yeah, it'll be in this court. And
Yeah.
on
so-
Mr. Hillman, let's see.
So,
On Mr. Hillman's
yes,
case,
yes, sir. 3.
that's a 3rd-degree felony. You're looking at up to 10 years in prison.
Yes.
Do you understand, sir? And if convicted, you're Corey Hillman, right?
How am I looking for?
Wait, are you Corey Hillman?
Yes, sir.
Okay. You were indicted for evading arrest or detention, and it's a 3rd-degree felony. So it carries with it up to 10 years in prison. Yeah. But he told you that, didn't he?
I know, but I was not running. I literally was not running from the guy.
That's not the debate. I mean, we're going to have a trial and then let the jury decide. But I'm looking at the probable cause affidavit, which is pretty thorough here. It's about 20 lines long. And it says, You had an outstanding city of Port Arthur warrants for your arrest.
No seatbelt.
No, I'm sorry. I'm sorry. It doesn't matter. All they know is there's a warrant for your arrest, and then that means you have to be stopped. They don't know what's the facts. And they just know there's a warrant, and that's all they know, and they stop for the warrant to be determined. You know, are you going to talk over me all day long or just be rude? All right. You sit over there, right over there. You're in timeout. Sit right over there until you can obey the rules. John, what are you working on there?
I got a plea on Fowler. I'm trying to get right now. We can go down to my announcements. I can make announcements in all my cases. And let the court know what we're gonna do.
All right.
All right.
Okay, I've got Christopher Chambliss.
Your Honor, I filed a motion to have him evaluated.
That's an MTRP?
It would be in a new case, yes. And we've filed.
Okay, hold on.
Evaluated.
Motion to revoke probations. Hospital personnel. Well, what was saying? Well, this year we go.
You know what I want to do?
Look, John, you got to do more than this. I mean, these are just conclusive. There's an issue. I mean, I can't get that. That has to be articulated and put spelled out because everybody can get a motion granted for this. I mean, it has to be spelled out.
Let me refile then, Your Honor.
Oh,
I can do a better motion. I just use standard form. I'm sorry, I just use.
He's on probation for third-degree felony, so it's going to be in this court, this new case, third-degree felony. We're going to handle the motion to revoke probation primarily. I'll take care of that. It's setting that. We'll set that for a hearing as soon as you can get that and the doctor
refile that today, Your Honor.
Thanks so much. There's two cases. Then I've got Jordan Dale. That's another NTRP announcement.
Your Honor, that one, the underlying case is a Houston case. My client's indicated that
let me see.
Dismissed.
So that's going to be dismissed. It's indicted and setting for August 28th.
I was going to check. I was going to say, let me follow up on that to confirm that because I just go up saying so.
So what are we going to do on it? It's alleging an unlawful use of the motor vehicle, right, as a substance, which gets my attention. Substantive crimes. What is the state moving on that or no?
On what?
The Jordan Dale, right?
Yes.
Yeah, we're moving forward, Judge.
Oh, okay.
I mean,
all right.
And we'll set it for a contested hearing.
Yeah, set it for a hearing. Motion to revoke probation hearing, please.
Sounds good.
Then where's he in custody?
Custody, yeah.
Okay. Jared Fowler.
That's what I'm working on right now, Your Honor. I haven't worked on it.
All right, thank you. It's noon.
Yeah, I know.
We're all tired. Whatever you can as quick as possible. Daniel Jenkins.
I'll follow an evaluation of that, Your Honor, but I'm probably gonna have to add some more stuff to that too because I use my standard form. So just redo that.
Daniel Jenkins.
Yes.
Okay. Daniel Jenkins. And two MTRPs.
Yes.
All right. Then those are going